Okay, with that being said, I will call to order the Lost Pines Groundwater Conservation District Board meeting Wednesday, December 16th, 2020 at 7:02 p.m. The meeting is being conducted as a telephonic video conference meeting pursuant to the Office of the Governor's temporary suspension of certain Open Meeting Act laws due to the novel coronavirus. I welcome everyone to our meeting tonight, and we have a rather long agenda. I did receive requests to address the board under various items. Everyone that I received, I responded back to confirm that I had received their request and advising everyone that the 3-minute rule would apply in their discussions with the district. So with that said, I will move down.
A clarification on public comments that are to agenda items, especially for the presentations. Will those folks make their comments before the presentations or after the presentations? When will you allow that?
When we get down into the agenda items where there's going to be presentations, they will make their comments to the board after the staff has given their presentation on the item.
Good, thank you. I think that's appropriate.
Okay. With that being said, we will drop down to item number 3, which is public comments. And I will call the people who, in the order that I received your requests. And the first one I received was from Mr. Andrew Weir. Is Mr. Weir on?
I am. Thank you, Mr. President and board members. My name is Andy Weir. I'm a resident of Bastrop County in Circle D subdivision. I have a registered exempt well in the Simsboro formation of the Carrizo-Wilcox Aquifer. Tonight in this public comment, I just want to encourage the board to intensify their proactive approach in fulfilling their statutory duties. And I want to remind us of what those duties are. The groundwater conservation districts are the state's preferred method of groundwater management in order to protect property rights, balance the conservation and development of groundwater to meet the needs of this state, and use the best science available science in the conservation and development of groundwater through rules developed, adopted, and promulgated by a district in accordance with provisions of this chapter. And I'm sorry for kind of preaching the Bible on that, but I want to focus on 2 phrases in there: balance, conservation, and development, and the promulgating the rules developed by the district. So conservation and development, when I look at the links and the documents that are available at the Lost Pines Groundwater Conservation District website, there's very little information about conservation. Frankly, there's no balance there. And it's heavily weighted towards development. And there's very little public engagement also, or promulgating the rules of the district that I can find. And I attribute this to the fact that the district, since its inception, has been heavily engaged in the permitting process. So that's very understandable. So I want to volunteer, again, the second time I'm volunteering to assist the district to bring more balance to the information that it shares through the website, through local press, and through public presentations. I have some experience in this area. I'm a photographer, I'm a videographer. I will retire this coming May from 30 years of state service. Among those jobs I've done is manager of public information and consumer affairs at the Commission for the Blind. I was consumer affairs coordinator with the Texas Youth Commission. I'm a member of Rotary, Lions, and Chambers of Commerce over the years, and I understand how powerful these organizations are in getting information out and shared in a community, especially in Lee and Bastrop counties is where I've done most of my time. So the second way in which I encourage the board to be proactive, to get out ahead of the curve, is I want to encourage the board to direct staff to create or begin the creation of a water well mitigation program. I think the board's going to hear a lot tonight and in the coming months about the effects of Vista Ridge pumping, specifically on Lee County residents. And you know better than anyone else that your own district has its own large permits. And even when you balance conservation and development, there's going to be impact.
Your time is
Okay,
up.
thank you very much.
The next person that has requested to speak is Miss Lynn Chansey, I believe from the LCRA.
Yes, thank you, Chairman Talbot and members of the board. My name is Lynn Clancy. I serve as in-house counsel at the Lower Colorado River Authority, and I'm offering these public comments generally with regard to the process by which the board is conducting its business during the pandemic. And in particular, with regards to items that have the potential to be controversial or have significant public interest. Specifically, LCRA supports the board's fair and non-discriminatory handling of pending matters. Based on the public comments that were offered in November with regards to several items that are again on the agenda for this evening, it's apparent that many items are controversial in nature or have significant public interest. The board appears ready to move forward with one or more of these items, despite the fact that it has continued to delay consideration of others, recently suggesting that it might wait to take those up until COVID's over. Postponing consideration of some matters, but not others, even when delayed items have been pending longer, is unacceptable and unreasonably discriminatory. This is particularly the case given that the board has already proven its ability to conduct business in a virtual setting on all other matters. As your counsel, Greg Ellis, recognized last meeting, courts are conducting hearings all over the state, even holding jury trials in some cases. State agencies, city councils, and other local governments, including other groundwater districts and river authorities, are conducting business in a virtual or hybrid manner, all while providing for appropriate opportunities for the affected parties and public to engage as required by state law. While no one is a big fan of this approach, for sure, these entities are nonetheless meeting their statutory obligations as required by the state laws they're charged with implementing. To that end, LCRA urges this board to do the same. If the board finds it's willing to take action during a virtual Zoom meeting on any of the controversial matters or matters of significant public interest on tonight's agenda, it should be willing to move forward with all of them. That concludes my remarks. Thank you for your time and consideration.
Thank you. Okay, thank you very much, Ms. Clancy. The next person who is requested to address under public comments is Mr. Stan Mitchell. Mr. Mitchell. Is Mr. Mitchell present? Okay. Then the next person is Mr. Steve Chamberlain.
Yes, thank you. Members of the board, my name is Steve Chamberlain. I'm a landowner in Cedar Creek, Texas, and I'm a native Texan, and I will keep my comments brief. I've tried my best to follow what's happening to our groundwater, which is, in my humble opinion, and by all accounts, a complicated rat's nest of self-serving speculators who have no interest at all in what the board really stands for. As far as I'm concerned, we landowners in these two districts, both the Lost Pines and the Post Oak districts, have been forced to witness our Alamo and our Goliad. These people have had us on the run for years. What I want to know is, when are we going to get our San Jacinto? Or are we going to let these people run us out of the state? When are we, i.e. the board, going to stand up and fight now that the marketers are circling the wagons? What does it tell you that the same attorney that represents Vista Ridge is here tonight, now representing Recharge? I was a union representative for many years who had to stand up for the people up against the leadership of the union sometimes. It wasn't comfortable. I know it's hard to do, but I had to realize who I really work for. Not the union leaders, but the people who are working their tails off every day, the poor common folk. It was the little people that kept us going. Now's the time for you, the board, to recognize that you are working to protect these people, us, the landowners. Thank you for your service, and we're counting on you. Thank you.
Thank you, Mr. Chamberlain. The next person who's requested comment is Miss Linda Cush.
Mike, before we proceed to Ms. Curtis, I show that Mr. Stan Mitchell is on the Zoom. If you want to ask.
Is he?
him.
Okay, then we'll move back up and take Mr. Mitchell first. Mr. Mitchell? Mr. Mitchell? Is he on?
Yeah, we could proceed to Ms. Curtis if you'd like.
Okay, we'll just, okay, Miss Linda Curtis. Linda?
Can you hear me?
Yes.
Hello, thank you for your time. I'm going to go light and fast as usual. As you know, I support this district. I'm on your side, even when I disagree, okay? Especially when we are working together to meet our legislative mandate to protect the water supply for residents of Bastrop and Lee counties. And I want to share with you a few facts that are simply pieces to a puzzle, now in search of additional facts. I want you to join me in finding, in the search to find out all the facts about what is really going on. On October 28th, and I'm going to send you this because I want you to have these dates, so you'll have it in writing for me. On October 28th, Post Oak Savannah Groundwater District sent out an email stating, quote, just as anticipated, some wells in the immediate area of the Vista Ridge well field are experiencing issues with their water wells, unquote, and, quote, there were no surprises. The aquifer acted just as we predicted, unquote, and, quote, for the most part, a simple lowering of the well below the new water level will solve the problem, unquote. Okay, I started getting, on December 1st, I started getting reports from Lee County landowners about well drawdown. On Thursday, December 10th, Gary Westbrook, Post Oak's general manager, announced at the GMA 12 meeting that Vista Ridge had shut down pumping on Monday, December 7th. On December 8th, at the monthly meeting of SAWS, San Antonio Water System, no mention of the shutdown was made, though clearly it impacts on their ratepayers due to a complex set of facts that I won't go into, but you know, they have to pump to meet their goals because they're behind schedule. SAWS, in fact, pulled their Vista Ridge briefings entirely from their agenda in November and December after having it on their agenda every month for a full 3 years. We believe pumping was resumed on Saturday, December 12th, as reported to us by SAWS senior management. My point is this, district board members, all the district's well owners, our district, well owners, landowners, businesses, homesteads, etc., have what's called investment-backed expectations. Our lives, our well-being, families, homes, businesses, and savings, that the district must protect. In other words, what our investment-backed expectations are the same. It should have equal footing with the water hustlers who insist that this only applies to them. Last fact I want to share is Mr. Terrell not only represents Recharge, as Steve Chamberlain pointed out, he represents Vista Ridge LLC. I already know what Terrell will tell you tonight. Either the facts I've laid out are circumstantial, or you should believe whatever he has to
Your
say.
time is up,
You should
Linda.
buy a bridge from him tonight. I'm done. Thank you.
You bet. Okay. Has Mr. Mitchell come back on? Mr. Mitchell? Okay, I'll move down to the next one. Miss Michelle Gangus. Miss Gangus?
Can you hear me, Mr.
Yes, I
President?
can.
Thank you. I'm going to be brief because I can tell you that I'm here to speak for myself and for the Simsboro Water Defense Fund. I'm Michelle Gangness from the Blue community in Lee County. I don't have a well, but I work with lots of people who do. And the Simsboro Water Defense Fund would subscribe to the comments made by Mr. Weir. I'll just amplify that those who want to develop and typically export our water are very good at maximizing development. So to whom do landowners and well owners look for the other side of that balance that we are supposed to achieve, that conservation balance? They have no one but you. So why does that matter? We believe it matters because sustainability of a water supply is the bottom line, the only thing that matters. I'm not suggesting that you can block exports altogether, but I do think sustainability of a project as a prerequisite to the ultimate sustainability of the resource ought to be your watchwords. I hearken back to 2005 when the Alcoa SAWS water supply agreement for at least 54,000 acre feet and probably a lot more was scrapped by the two parties. At that time, District Director and Board President Keith Hansberger was quoted in multiple media releases the district put out, possibly the last one I remember you putting it out. I remember you putting out. He said then that the amount of water San Antonio originally planned to purchase from Alcoa would not be sustainable for the aquifer, cut and dried, as he always was. The article went on to say, if large volumes are pumped over an extended time and no action is taken, there's likely to be a significant decline in water levels. Sawdust is hearing from what we think are some of the 258, by our calculation, well owners in the Carrizo in this district. Their water levels are dropping significantly at great expense for them a few short months after Vista Ridge started pumping the Carrizo right across the county line. It's not a coincidence, and Keith would not think he had been particularly prescient when he made his remarks. So I'm going to put sustainability on the table as the standard for the water marketers to aspire to, but the groundwater districts to regulate them to. And then I'll just mention some traits that Sawdust and landowners who support us would like to see this district live by. Being proactive, accountable, transparent, and show leadership and make policy so your staff and advisors can follow your lead. We appreciate you. We want to see you roll up your sleeves and keep working hard. And please abide by what we see on your website is your mission, and that is to protect our water supply. It's our lives and our livelihood. Thank you.
Thank you, Michelle. Right on time. Is there anyone who did not sign up to make public comments this evening that would like to address the board?
This is Stan Mitchell. I'm available by telephone.
Okay, Stan. Well, then you're up, and you got 3 minutes.
Yes, sir. Ladies and gentlemen, my name is Stan Mitchell. I'm a resident of San Antonio, and I buy water from SAWS, the San Antonio Water System. As you know, SAWS, a San Antonio-owned water wastewater utility, has built a $3 billion pipeline to deliver water uphill from donor counties in your area to San Antonio to deliver water at the rate of 50,000 acre-feet per year. Several of us have been critical of the drawdown of water from sources 142 miles away, especially in light of hydrological reports that question the rate of recharge in the aquifers that have been tapped. Now there are rumored instances of wells in your area running dry, and indication of receding shorelines in your underlying aquifers. As we oppose SAW's policies that contend with your landowners for available groundwater, we want to inform our city government at the earliest opportunity that the water supply we are relying on for the next 30 years, renewable for another 30, may not be available for future generations. Our SAWS utility has not reported any Vista Ridge pipeline supply issues, so I hope to learn what is happening at your end of the pipeline. There are those in San Antonio who care about the well-being of rural Texas. Please let me know at your earliest convenience when you have evidence that our Vista Ridge water supply may be in jeopardy, even though I know you did not permit Vista Ridge. Even now, as you consider subsidizing landowners who must deal with sucking air, you have a message to share with us San Antonio residents. Your experience may be our canary in the coal mine. As we work through the increasing claims on declining water resources, full disclosure will be our friend. I hope I have brought sunshine to this existential issue. Thank you for this opportunity to share information, and a healthy Christmas to all.
Thank you, Mr. Mitchell. Appreciate your comments and taking time out to make your comments this evening.
Thank you.
That now completes everyone who sent a request to me to address the board in public tonight under public comment. But is there anyone present or tuned in that did not sign up but would like to address the board?
President Calvert, this is Judge Fisher. How are y'all doing?
Just fine, Judge. How are you tonight?
Okay. Hey, most likely you cannot see me, and that might be for the good that you cannot see me. So I just want to say a few words. I've been watching all of this. I've now gotten phone calls concerning the drop in the water level to some of our landowners. I am real concerned that we have only begun to start really pumping. And that's just Vista Ridge pumping right now. And, you know, we still have a few of them out there that are going to get online to pump water. You know, the landowners and the well owners, they're going to pay a price. And we're starting to see it. They've got to drop their pumps. They've got to get bigger pumps. And, you know, SAWS is going to be sitting there making money. Vista Ridge is going to be making money. And the landowners and the well owners, it's going to cost them money. And I am requesting of the board to really take a look at it. And I know further down the agenda, I see where y'all will discuss of monitoring wells. I think that's very important that we need to have them. And I just hope we have a plan that when it really starts drawing down of what are we going to do. That's all I've got to say. I just wanted to bring to your attention that I have a big concern down here in Lee County. Thank y'all very much. Thank you for the job that you guys are doing. I want to wish every one of y'all a Merry and blessed Christmas. Have a good evening.
Thank you, Judge. Since you mentioned it, and it is an item on the agenda, I can comment on it, and that's on item number 9 this evening, where we call for the creation of a monitoring committee. Under our management plan, I am charged with the creation of committees. It was quite evident to me after our last board meeting that there were a lot of issues floating out there, a lot of concerns, and felt that action should be coming forth from the Lost Pines Groundwater Conservation District. I immediately the next day went to work and worked with staff in the development of this monitoring committee. Under our management plan, I do not need board approval, but in the spirit of transparency, I wanted the public to be aware of the nature of the monitoring committee. And as you said, we have to develop a plan. And it reminds me, maybe not as dramatic a time, but when President Kennedy was initially confronted with the Cuban Missile Crisis, and he was being peppered internally within his own staff and military of different plans and how to respond to that. And President Kennedy responded, "We're going to do something, but we got to know what we're going to do before we do it." And that is why I expedited getting this committee put together and on the agenda for this evening. With that said, anything else from the public? Okay. Item number 4 is an action item. It is review and approval of the minutes of the November 18th, 2020 regular board meeting. Those minutes were included in the board packet this evening. And if I hear no objection to approval, I will call that they are approved. Is anyone objecting to the minutes that were submitted for this evening? That being said, the minutes have been approved. Number 5, consideration and possible action on the 2021 district calendar. I will say that I'll have to turn this to staff. I have spent so much time and my desk is covered with paperwork, but in the agenda, there was not a calendar. So I don't know what we're expecting to cover with this district calendar. Mr. Totten, would you like to address this item, please?
Yes, sir. Unfortunately, in our rush to get out of 2020, we forgot to include the 2021 calendar in the board packet. So we'll need to table this item and come back to it in January. This is a housekeeping item that we do every year just to make sure that we don't have board meetings falling on holidays and things like that. Typically we do it in January, but like I said, we were just in a hurry to get 2020 finished, and we didn't include the calendar for y'all's consideration tonight.
Well, I understand that completely. And I know how busy you've been the last few weeks. And so I am going to table this item until the January meeting, unless one of the directors is objecting it. Okay, then the 2021 district calendar will be on the January agenda for action. Thank you. And it is tabled for this evening.
Mike, this is Natasha. If we could go back to item number 4, approval of the minutes, before proceeding to number 6. I didn't hear a motion in a second on that.
I didn't. What I said is the minutes will stand approved if no directors object to approval, and no one objected, so they're approved.
Oh, I understand that, but if you could still ask for a motion in second, and then the vote is the next.
I'm knowing that other political subdivisions, when they have a long agenda, Natasha, are taking an approach. If there's no objection and no discussion, by fiat, it's approved. And I just, no board member objected, no board member made an amendment to it. So hearing no, the minutes were approved. And we did that last month.
We did, but we also did it with the motion and second. I understand the need to save time tonight, I absolutely do. But you can still save time by doing it your way, but the motion and second initiates the vote.
Okay,
I'll make the motion to approve the minutes as included in the packet.
I second it.
I have a motion and a second to approve the minutes of the November 18th meeting. If there is no objection or no discussion, the minutes will stand approved. The minutes are approved again.
Thank you. I appreciate
Item number 6 is consideration of the financial report for the period of November 1st through November 30th, 2020.
Mr. President, members of the board, the financial report for the time period ending November 30th, 2020. The district operating fund balance stood at $369,203.42. The tax pool fund balance was $3,206,600.39, giving us a grand total of $3,575,803.81. User fees collected to date are tracking where we'd expect to be for this time of year. We're about 100,000 off of what we had budgeted for, and we basically got 1 month left to go. And that we'll collect some of those fees in December, and then the remainder of it will come in January for the December time period. So we're pretty much on where we'd expect to be for this time of year. Our expenses are all tracking where we'd expect to be as well for this time of year. You can see the functional balances are getting fairly low on most of our labor-related items. However, under supplies, professional services, and operating expenses, we still maintain fairly healthy fund balances in the majority of our line items. As you see on the agenda, we do have a budget amendment coming to you tonight to make a few small corrections. One of those was one that was initiated back in February or March, and we never got to finalize it, but we'll come to that shortly. But at this point in time, with regard to the budget, I think that we're looking to end the year in fairly solid financial state. I don't see any upcoming expenses that still affect the 2020 budget. And hopefully when we approve the 2021 budget, we'll be able to make that work just as smoothly as the 2020 budget is operated.
Yes, Jim, I'm in agreement with your comments. And I at this point feel very comfortable. If the trend continues, we will probably exceed the fiscal year with an increase in the fund balance in excess of $600,000, which is, I believe, more than last year. So the district is in sound financial shape. I can tell you a lot of political subdivisions wish that they could report that type of fund balance. But I also think it's going to become a challenge for us as the board, what we would like to do with the amount that has accumulated next year, and maybe addressing some of the issues that have come before us publicly. That's the only comment I have regarding the budget. If there is no questions, I would entertain a motion that we acknowledge the acceptance of the financial report for the period of November 1st through November 30th, 2020.
Earl Steinbach, I move that we accept the financial report as presented.
Fleming,
Larry
second.
Shoddy, I will second that.
Board Member Steinbach moved and seconded by Board Member Shanti that the financials for November 1st through November 30th be accepted. All those in favor?
Aye.
Aye.
No objections?
Aye.
The motion is approved. The next item on the agenda is consideration of and possible approval. Oh, I'm sorry, excuse me, it's number 7. Consider of and possible approval of a budget amendment number 1-2020. Jim, that is in your packet tonight. And you mentioned that you'd be going over this as you reviewed the financial report. So I will turn it over to you.
Thank you, Mr. President, members of the board. The budget amendment that's in front of you is essentially we're moving around $20,000 around within the budget to fill in a couple of holes. The largest, what we're looking to do is move $14,000 from our contingency line item and an additional $6,000 from legal notice, which we aren't going to need before the end of the year. The $14,000 would be moved into line item 5325.3, which is the line item set aside for the employee match on the district's retirement fund that was created this spring. At the time that the retirement fund was created, we knew we were going to have to move money into a line item to support that. But unfortunately, COVID came up and this budget amendment just never got done. So we're bringing that to you now to fund that employee match. The remaining $6,000, $5,000 of it is moving to line item 8,600, which is our website expenses. That'll bring us up to a positive balance of about $2,400 on that line item. And the last additional $1,000 will move to function 8694.1, which is office equipment, to make up for a couple of pieces of, as you imagine, we've had to buy some new filing cabinets, some other things in the office. And so this kind of brings that balance back into the positive.
Okay. I will entertain a motion to approve these budget amendments, and then we can get into a discussion if the board has any. Is there a motion to approve the budget amendment 1-2020 as submitted by the general manager?
Jermaine, I move we approve it.
Okay. Board Member Semaine motions to approve.
Carl Steinbach seconds.
And Board Member Steinbach seconds. Is there any questions from the board? Is anyone going to vote no? Then the amendment's approved.
Thank you, Mr. President, members of the board.
Okay. The next item is item number 9, consideration of and possible approval of proposed changes to the personnel policy. Jim, I don't know if you want to take this or Director Fleming wants to take this. And I will save my comments until after the presentation is made.
Well, I think Director Fleming, if he's available for this one, this was kind of his idea, and he initiated this during the discussions with the budget committee. So I think it'd be appropriate for him to go ahead and lead the discussion on this one.
I thought I saw his name flash up, so I believe he's present.
Yeah, I'm here. The memorandum is pretty self-explanatory. If you've read the memorandum, it's very simple, and I will stand for questions or any comments that you may have. It's just a method of giving some flexibility to the employees so that they are allowed to bank some of their vacation time to save up vacation time, but it's limited to the amount that they can bank. And it also allows them to carry over their sick leave in case they were to have an issue, which those kind of issues came up in the COVID deal. And I know that there's been a situation in the past where an employee had to have a surgical procedure and basically had to take time off to recover from that procedure. If there were a complication or whatever, then that employee would not have had any sick leave to carry over. So it's just a flexibility issue. I think it's a great benefit for the employees, and I support this.
Thank you, Director Fleming. My comments are somewhat similar to Mr. Fleming's. We are in a market today where qualified workers are difficult to find. And I think if you would look at a lot of what I call the political subdivisions, such as cities, counties, special districts, they have a policy similar to this. This is somewhat of a non-financial policy that benefits our employees. And I think this is a very good policy, the way that Mr. Fleming has put it together. I appreciate him bringing this to the Budget Committee's attention, and I fully support it.
Mr. Chairman,
David, I do support your policy. I just have a couple of small questions. And I take it your recommendations are coming out of the Personnel Committee, and they're behind you on your comments on this?
Actually, it's coming in from the Budget Committee. They're behind me on this item.
Now, the only other question that I have, and I have no expertise in this and very little experience with it, but it's my understanding that you're recommending that all vacation days can be carried over without limitation?
No,
it's limited.
Go ahead, Mike.
Well, it's limited to 10 days. And we discussed that at the budget meeting. It couldn't be wide open because that could create a financial impact on the district if it was wide open with no limit. And in all the cities or governmental entities that I've been affiliated with, and the number of personnel manuals I've written over the years, I'm not aware of any of them that did not put a limit on how much vacation pay you could accumulate because of the financial impact it could have.
If you look on the second page.
I misread that or misunderstood. Yeah, I'm good. Thank you.
Okay. It's on the second page under the vacation, the recommendation, an employee may carry over a maximum of 10 days of vacation time from one fiscal year to the next. Any vacation time not used in excess of the 10 days carryover will be forfeited.
Thank you.
Mr. Talbot, Samang again.
Yes, sir.
I commend the committee on bringing this forward. Quite frankly, it's, in my opinion, long overdue.
Yes, sir.
I don't want to get into a heavy discussion on it tonight, but I think it's a little light insofar as the 10-day limitation. And I would also hope that at some point in time, the committee would look into a sick leave bank where the employees could give up their sick leave to somebody else who had a major catastrophe or something and needed it.
Okay.
All that being said, that's not before the board tonight.
But that is a very, very good point. Very good point. We have that at Aqua, Mr. Samang. That's a very, very compassionate, very, very compassionate of it.
Yes, and I appreciate that. And
so I move that the recommendation be accepted as is, only to conserve time tonight because of the long agenda and not get into a long discussion on it.
Okay.
And secondly, to give the committee time to study it, look over it, and perhaps bring some amendment to it in the future.
We will. Thank you very much. Is there a second?
I second.
Councilmember Semang recommended approval with some future items to be addressed. Board Member Cook seconded. Is there anyone opposed to the approval of this amendment to our personnel policy? Then the policy change has been approved.
Thank you very much.
Okay. Item number 9 is discussion and possible action on the formation and the appointment of members to a monitoring well committee. I am not going to get into the legislative committee tonight. I understand that our legislative consultant is wanting to streamline how we currently handle legislative matters. Looking back when this was last brought before the board, there was extensive discussion. And at that time, the board was fairly adamant that the board remain as the legislative committee. And I would like to discuss this in a little bit more detail with Mr. Ellis, as well as have this as a specific action item by the board, because I think legislative matters affecting the board is something that needs to be understood by all of the board members. So we're only going to deal with the well monitoring board. As I stated at the commencement of the meeting tonight, this is in response to our November meeting. I committed that I would, as your president, create a groundwater monitoring committee based upon comments we heard in November, as well as comments we've heard this evening. I believe that it's very important that we get moving forward on this. I would like the board's concurrence because I feel it's such an important matter that I think we should all be on sync with this. I think once the committee gets operating, we may make some adjustments to some of the items that are listed here, or tweak them somewhat. Under the management plan, I am charged with the appointments. The appointments will be made by no later than next Monday, and those will be sent out to the board. Because I understand the urgency. I'm in hopes that the committee will take the initiation of calling a monthly meeting, become dictatorial and getting down to some minute details. But I will be monitoring it. And I believe initially there should be a monthly meeting and discussing this matter with Mr. Totten and Mr. Donnelly. There's a lot of work that needs to be done by this committee. Tonight was the first time I've heard that residents in Lee County are now experiencing some fluctuations in their well levels, and I think that's that is the first I've heard of that, and I think makes this committee ever more important. Also under the management committee, I am not obligated to appoint board members. I can appoint board members and citizens. It is up to my discretion, and I'm still reflecting on how best to get this initiated. And then also under the management plan, I can remove a member without cause, which is not my intent to do so. But again, I want this to be a working committee. With that being said, I'll be glad to answer any questions that the board may have on me regarding this monitoring well committee. With no comment, the committee is approved as written, and appointments will be made by next week. And secondly, Mr. Totten, make sure that we put the legislative committee item on for the January meeting. Okay. Thank you for your support in this matter. And I might have surprised some of you responding so quickly, but I did come away from the November meeting clearly understanding the importance of this issue. 10, item number 10 is an action item. It is consideration of and possible action regarding the district's 2021 budget. This is being submitted by both the general manager and the budget committee. I will let Mr. Totten touch over the high points. I don't want to steal any of his thunder, but in light of creating the well monitoring committee, we also have increased funding for monitoring wells considerably for the 2021 budget. Jim, take it away.
Thank you, Mr. President. And yeah, so the 2021 budget was provided to you as part of the packet. What you'll see is that it is remarkably similar to the 2020 budget that we're currently operating under. There are some changes. We essentially doubled the amount of money that's set aside for special projects and water testing. That's money that's typically used for water quality tests that are conducted for landowners within the district. That gives us a lot more flexibility in not only the types of tests we can offer, but which laboratories we can take samples to. So that increased from a $5,000 line item to a $10,000 line item. Additionally, the audit expenses went up. What we've seen is that typically our audit expenses run about 10% of our annual operating budget. So 10%, yeah. 1% of the annual operating budget, I'm sorry. So with an operating budget of 1.3 million, we set the audit expenses to $14,000 for next year in anticipation of that cost. The hydrogeology and legal budgets remain essentially unchanged. Hopefully the legal will be sufficient depending upon how things shake out in 2021. The hydrogeology, we've consulted with Andy, and even with increased modeling and increased monitoring work out in the field, he's confident that the $200,000 line item there is sufficient to cover that. And as you saw in this current budget, we still have we spent about half of that budget this year, even with Andy doing a lot more modeling for us. So that $200,000 should be enough for us to cover any field work that needs to be done for additional monitoring, as well as any additional modeling that needs to be taken care of as part of either part of the GMA process or just to address the concerns within the district. With that being said, those are pretty much the major line item changes that you're going to see. There are some small changes here and there with regard to, I just lost my place on the agenda, or on the registration fees. We did increase registration fees to allow for more, to make sure that we have money available for more board members to attend more training. We felt that was a good place for us to put some extra money into. There's been a lot more interest in attending conferences. Hopefully, maybe in 2021, we'll see some in-person conferences, but even virtual conferences, we wanted to have money put aside for that to allow for more board member training. With that being said, I'd be happy to address any questions that you as board members may have.
Jim, I just, maybe I was in another meeting, but I thought we were going to increase funding to bring on another person to address.
Yes, we have a vacancy listed on the budget, but we did not discuss the details about what that position would be.
President Talbot, you're cutting in and out. If you don't mind restating that.
I'm sorry, I can't hear Jim. I'm sorry.
Okay, Mike, you might want to
Jim?
call in on your phone.
Who?
You, President Talbot, you're cutting in and out.
I don't know how, but.
Oh, you sound
what
better now.
number? Okay.
Okay, sorry about that.
All right, shows me having a strong connection.
Okay, you're fine now.
Jim, I didn't catch what you said.
Yes, sir. So we did have that discussion, and we actually listed a vacancy on the staff table, but at the time of the budget, when we were setting the budget, we hadn't really settled on what kind of a role that would be. And so we did not budget for that at this point in time. We can come back and have that discussion in January. And if we decide that we do want to create that position, then we'll fund it through a budget amendment at that time. But at this point in time, we didn't have a real firm handle on how we wanted that position to be created or what roles that was going to take. So, we'll meet with the budget committee in January and have some further discussion on that point.
Yeah, let's schedule a budget committee meeting for January, because I thought we had got a little bit farther on that, and I'd like to move that along.
Yes, sir.
Okay. Is there any other questions for Mr. Totten regarding the proposed 2021 budget? If not, I would consider a motion and a second to approve the district 2021 budget for next year.
Larry Shoddy, I so move.
Approval. I second. Fleming.
Director Shoddy moved, Fleming second to approve the 2021 budget. Anyone opposed to the adoption of the budget? The budget is approved. Item number 11, I just want to point out, I have two people who have signed up for the item number 11, Mr. Steve Weir and Linda Curtis sent a request to me that she wanted to donate her 3 minutes to Mr. Weir on this item. So Mr. Weir will have 6 minutes on this item. And the second person that signed up to address the board is Ms. Michelle Gangus. What we will do is after I bring it up on the table, the staff will give their reports, and then I'll call for the public comments. So with that, item 11, consideration of and possible action regarding the request of the Recharge Water LP for reissuance of the operating and transporting permits to reflect a March 9, 2020 2023 expiration date as a result of tolling of the permit from Tuchaku 58-55513, 58-55514, 58-55216, 58-55217, 58-55323, 58-57809, 58-55218, 58-47602, 58-47303, 58-47304, 58-48-212, 58-48-121, and 58-48-122 from the Simsboro Aquifer located in Bastrop and Lee counties, which the district has processed as a request for amendment of the dates of the expiration of the operating permit pursuant to Rule 7.2C and requested for renewal of the transport permits pursuant to Rule 6.6C. Natasha, do you or Jim wish to kick off first?
President Talbot, I will go first if now is a good time.
Let's take it. Let's go.
So just to reiterate, this is item 11 on Recharge's request for reissuance of its operating permits and renewal of its transport permits. So Recharge seeks to have their permits reflect the amount of time that the permits were not in effect after the final judgment of the trial court and before the Court of Appeals mandate reinstating the permits. That is 432 days. One moment here. Recharge also seeks to renew the transport permits and sync up the dates of expiration with the expiration dates in the operating permits as allowed by district rule and state law. As the proposed board order, which I believe is around page 14 of the packet, states there are no substantive amendments here to either the operating permit or the transport permit. There's only an extension to these permits that is based on the suspension that's created by the courts. So this item was taken up in November, and in the meantime, the board was provided with additional information. The district was a party to the litigation creating the suspension and is bound to obey by the decisions of the courts. The district can't decide not to comply with a court order simply because there's not a district rule that contemplates the order. If the district takes the position that because there's no rule allowing for this change, or that the board action was needed before the permit terms expired on paper, then that would be a problem for the district and could be taken as not complying with a court's order. At the last meeting, there was a mention of a stay of the permit following the final judgment at the lower court. And upon review of the record in that docket, there is no stay that was issued on the permits. Some might question, some might compare the district to a state agency, whereby their permits are often stayed on appeal. And that's not comparable here because the district didn't seek what's called a supersedious or seek to stop enforcement of the trial court judgment while the permits were up on appeal. For state agencies, supersedious is basically automatic because they're exempt from submitting an appeals bond. The district is not a state agency. So I wanted to clarify that there was not a stay or a supersedious here. There were some written comments submitted on this item, and I just wanted to quickly address those. Those comments called for the board to process this request under District Rule 15.1. And I got to back it up just quite a bit. District Rule 7.2C is the rule that we are recommending that the board process this request under. That rule allows for the board to consider a no increase amendment to the operating permits. And by no increase, we mean the production is not increasing, the rate of withdrawal is not increasing. That section 7.2C gives the board discretion to have a public hearing and an opportunity for a contested case process under 15.1. I do not recommend proceeding under 15.1. The written comments appear to be an attempt to relitigate the permit, and I would advise against that. Every issue that could be decided on the recharge permit has already been decided. In the law, we call this res judicata, which means that the matter has already been settled and cannot be raised again. There's no reason to relitigate the recharge permit when the only issue that we have here before us arose out of 2 court decisions. So, and also in our time, other board counsel, Matt Kutak, or district counsel, Matt Kutak, and I, we have not seen the district process a no increase amendment under 15.1. And we wouldn't advise starting now. There's a question about whether or not a request for renewal was submitted, or a timely request for renewal was submitted. And I would advise the board that a renewal application was submitted with Recharge's second submission on November 11th, 2020. And that renewal request did meet the district's rules under 6.6 for renewal of a transport permit. And that request was submitted prior to the expiration of the permits, including that 432 days. And so, you know, I would recommend, and as put in the materials to the board, the process laid out in the draft order, follow the no increase process to revise the permits to include that 432 days that already exists from these court orders, and renew the transport permits following the rules to sync up the expiration dates. And the new permits would actually expire on March 9th, 2023. And I'm available to answer questions.
At this time, does any of our board members have a question of our board attorney?
Natasha, Mike Samay. Does the court order put the 432-day extension back upon us and order us to do that?
So, Director Semang, the order does not expressly state that the board, you know, go back and reissue the permits. It would have been nice if the Court of Appeals had stated that, but the Court of Appeals just vacated the trial court's order and sent the permits back to the district.
Natasha, this is Cheryl.
Yes.
So you're saying that there's nothing explicit written in the court order, that this is just something that is just customary?
Director Smith, I mean, this is a
For
new,
the 432 days?
Sure. This is a new situation that the district's been faced with. So I wouldn't call it customary, but you do have to read the orders, into the orders and what they did, essentially with the permits. So it's basically an understanding of what the orders did, but you know, you have to look back at what the district's authority is subsequent to order 1 and then after order 2. And if Matt Kutak wants to add anything to that, he's welcome to.
The only thing I'll add is I think it's very clear that the first court order invalidated the permits, and the Court of Appeals mandate reinstated them. That, in my view, creates a sort of tolling of the permits. And I don't think that the board is necessarily approving that sort of extension. I think the Court of Appeals and the trial court created that extension for that tolling of the permit.
So the board is just recognizing the tolling in the permits.
And is it fair to say that we really, neither party had control over the time that was going to be involved while the appeal was going on? That we would accumulate the number of days that have been accumulated. I mean, we had no control over it. And I don't believe the other party had control over it.
That's right, President Talbot.
It could have been 1,000 days. It could have been 5 days.
That's right.
Natasha?
Yes.
It's Kay Rogers. When the Third Circuit Court of Appeals reinstated the permit on March 18th, 2019, I'm just wondering why so much time ran by before this issue was raised with the board.
Thank you.
Well, so I believe March 11th, 2019 was the mandamus coming down, but in January 2019, and I can't get too far into this, but there was an executive session with the board regarding, what would happen to the recharge permit.
Okay.
Depending on whatever outcome we would get at the court. That executive session was January 16th, 2019.
But I think Natasha, I think what Ms. Rogers is asking is the time frame after the court has ruled, and from that point getting back to the board.
Well, President Talbot, I think part of it depends on, when we received requests from Recharge. We did acknowledge it, the court's decisions in a letter in April 2019. But the request from Recharge was submitted in October 2020. So that's why these discussions are really happening now.
Right. Does that answer your question, Kate?
Well, I think the timing of it, because I wasn't here, I've just been here a short time, so I'm just trying to take in this entire calendar. But I can't help but feel like the board's being asked to extrapolate something among some court orders that wasn't specifically put in there. And then everyone's saying that this is just understood. That is it understood by a board, or is it understood by lawyers, or is it understood by the court? I don't know.
So I guess Director Rogers, there is the argument that this extension already exists. And so the board, doesn't necessarily have to put the termination date in the permits. But in order to have, accurate permits, Recharge has requested that it be reflected in the permits. And, I won't speak for Recharge on why that's necessary, but at least from the permitting perspective, it's good to have permits reflect the accurate expiration date.
Okay. Natasha, the way the agenda is written, we cannot go into executive session on this item tonight, if I'm reading it correctly.
Well, President Talbot, the board can go into executive session on any posted agenda item if it is necessary.
Okay, I thought that had to be stated on the agenda.
So it is on the agenda that the board reserves the right to convene into executive session. But, you know, we didn't, and you don't have to expressly list each executive session item. But we do have the proviso at the bottom of the agenda that the board could go into executive session on any item.
Okay. Does the board feel that we need to go into executive session on any of these points that the attorney has outlined for us?
Before we do that, I would like to hear the rest of the presentation.
Okay. Is there I'm out.
President Talbot, I believe 2 people have asked to at least.
Okay.
3 public commenters have signed up on this.
Yes, they have. We have 2 people that have signed up. And the first one is Mr. Andy Weir. And as I stated, as I brought this item up on the agenda, he has a total of 6 minutes to address the board on this issue because Ms. Curtis did write me a letter requesting that her 3 minutes be transferred to Mr. Weir. So Mr. Weir, you're up.
Thank you. Thank you, Mr. President, board members. I'm Andy Weir. I'm a resident of Bastrop County. I have a well in the Simsboro formation of the Carrizo Wilcox. I wrote the 4 pages of comments about this topic that Natasha referred to, and I think was shared with you all later today by President Talbot. I'm not a lawyer, but I do have a copy of the permits as they stand, and they terminate on September 21st, 2019. That's the only legal document that exists for these transport permits for recharge. And so that was my whole issue, was saying, as a lawyer, most people hold by the legal document. So as Director Rogers questioned, I would question if this extension was going to be an issue because of the court order, that there should have been some action to that regard to change the official legal document that exists for these permits. It didn't happen when the order came down. It didn't happen after General Manager Totten wrote to Recharge seeking debt collection for them to assume paying their monthly payments. And he states to them, you don't have to pay the back 14 months because we considered the permit suspended. But that is in no way a legal document or official proclamation that can change that expiration date that sits on the permit. And it's still there tonight. Then when the permit would technically expire on September 21st, 2019, you would think that either the district or Recharge, through their counsel, would correct this legal document. I think what you have facing you tonight is a boondoggle. It was unusual. It's the first time the district has had to deal with the permits were vacated or the decision was vacated by the third court, and that reversed the 21st District Court that had voided the permits, and how you deal with that. Again, in legal documents, and as I said last month, if I lease a car, I have a term on that lease. If I get hit by someone and my car is not available to me and it's tied up in court until I get someone to finally pay for my repairs, nothing changes on the terms of my lease. My payments don't get delayed. My lease doesn't get extended, even though I had no access to the use of my vehicle during that time. Just like Recharge had no access to their permits during that 432 days. There's nothing legally binding that requires that. The supersedious, the district decided not to pursue the supersedious. Recharge had the ability and the right to seek supersedious to protect their permit and to stay that order by the 21st District Court. They didn't pursue that at the risk of losing access to their permit. And so they went in with I would say, full knowledge that they gambled that they would get the permit, but then that they lost 432 days of the permit that was available to them. That was at their discretion. That was at their decision. It's not the responsibility of the district to control their permit and what legal decisions they make. So I think the date, look at the website tonight, look at the documents anywhere in any of your Lost Pines offices. The date on that document signed by President Talbot is September 21st, 2019. That's the expiration date. No one has taken the time or the effort to correct the single legal document that is a question here. No assumed extension, no implied extension or tolling of the permit can be added to that. It's there, it passed, it has expired. We need to move on. Thank you.
The next person is Miss Michelle Gangus, wishes to address the board on this item. Michelle?
Yes, sir, Mr. President. Can you hear me? I had trouble unmuting or muting or whatever I was trying to do.
Okay, no problem. We can hear you now. Thank you.
I don't want to take a lot of your time. I subscribe to Mr. Weir's comments. A lot of us have given a lot of thought to this, and I was interested to hear the discussion tonight. So Director Simeng says, was there a court order to extend the 432 days? I think the answer to that was nothing in the order of either court said that the permit had to be extended. Director Smith, Cheryl Smith asked, is this customary? There's nothing explicit anywhere, so is this customary? And counsel answered, this is a new situation, so she wouldn't call it customary, yet I find it extraordinary that she recommends against any extraordinary treatment by the district of this question, because as she says, you haven't come across this question before, so there's no reason to do anything different than you've done in the past. I would question that you need to be open to new situations and treat them accordingly. So I think treating this under 15.1 is not a blatant attempt to relitigate the permit. It's an attempt by those who argue for it to secure some due process here on a 432-day extension of a permit for 46,000 acre feet at a time when we're facing wells going dry from pumping in another county, another district of 50,000 acre feet, but only 15,000 acre feet in the formation that's being affected. So what is ordinary or customary about this situation? Nothing. And I think Andy has ably presented an argument about the export permits. I didn't hear any precedent for the 432-day extension. I didn't hear any reason why the district could not have filed for supersedious, or was advised not to, or was advised to do and decided not to. Never saw any official action taken on that point whatsoever. So if you took it in executive session, I hope you told us about it when you came out, but I don't think you did. So who made the decision not to file supersedious? I don't understand why you could not have done so, and I don't understand why Recharge could not have done so. So I'm a 45-year lawyer, and I don't profess to be any great thinker, and I'm not a litigator, but something about this just doesn't seem right. And it's been too long. It's simmered till everybody got their stories straight for what they want to have happen here. This is 2020. This could have been handled a long time ago, and this is part of my beef, if you will, with the district about transparency and accountability. I don't think you even knew, board members, what happened here. And now you have to accept an explanation of it because there's no way to recreate exactly what happened. I don't think Mr. Totten was authorized either apparently or explicitly to extend that permit back then when he wrote that email. Why not make it formal at that time? I could go on, and I'm sorry I'm being sort of rambling here, but it's really, I find it extraordinary that this can't be treated as something that needs to be treated as different and new, and don't rush to judgment on it. Thank you.
Time is perfect. You're up. My apologies. I assume the applicant is present tonight, and I would like the applicant to be given an opportunity to address the board regarding the board attorney's presentation, as well as the public comments that the board has heard tonight.
President Talbot, this is Shannon Rutherford on behalf of Recharge. Can everyone hear me fine?
Yes.
Great. I'll be very, very brief. I support and agree with your district council's analysis of this issue. I want to make something very, very clear. The operating permit on its term, on its face, let's all ignore this 432 days issue. The operating permit on its face does not expire until January 1st, 2022. State law, which was changed in 2017, requires that it was the last session, requires that the district align the term of a transport permit with that of the operating permit. So if this 432-day issue isn't even before the board now, Recharge's transport permits are extended by virtue of law with no choice by the board until January 1st, 2022. And we could go through this whole process as to the court issue separately. Obviously, the remedy would be for Recharge to go back to court and enforce the Court of Appeals judgment. The district's bound by that judgment. The district was a party to that litigation. This is a fully litigated permit. All we're asking is that the words on the permit reflect the legal reality. There's been a lot of attempts to confuse the issue. The issue is very simple. That's all I have. Thank you.
Okay. Thank you. I'm sorry I got knocked out again. I don't know what's going on here. Give me just a minute here. All right. I apologize. I don't know what's going on here. I'm coming back up. Oh. Well.
We're hearing you just fine.
Okay. Okay. I'll try to get me back on. Does the board wish to go into executive session at this time with the board attorney regarding this matter? If you don't, this is an action item. So I will, before I ask for a motion, if you're not wish to go into executive session, do you have any additional questions of either Natasha or Matt regarding this item?
This is
Okay.
Cheryl.
Pardon?
I just had a question. The comment that the
Okay.
board does not have a choice, then why is it before the board? Why isn't this just some administrative paperwork that the director can take care of?
With all due respect, that's exactly what it should be. It should just be an administrative action. I don't think a renewal is required for the transport permit. Under Rule 6.5 of your rules, the term of the transport permit should simply be extended. I understood that there was an opinion. I'm not sure where that opinion came from, that a renewal was requested. So in the alternative, we brought it before the board as a renewal. This should be an administrative act.
Director Smith, this is Natasha.
Thank you.
And this is Natasha.
Yeah.
So, yes, I think something like this would lend itself to be administrative, but for the district's rules not providing an exact method to do this administratively. I mean, the board has authority to grant the general manager, broad action authority to handle the affairs of the district, but that hasn't been done here. It could be done, but without that, if you're following the rules to the T, it would be appropriate to handle this as a no increase amendment, because basically no terms of permits or conditions in permits can be changed without an amendment according to 7.2.
I just want to apologize, Natasha and Director. I thought the question was directed to Recharge, and I apologize for jumping in there.
That's okay. Glad to hear your response.
Of course, that was his response, but
I guess yeah.
Did you have anything else, Director Smith? Did that answer your question?
I guess I'm just still puzzled again why it's a renewal as well, when it's really just, putting the export permit with the operating permit. It's not really a renewal of anything, right?
So
Am I taking that right?
It would be a renewal of the transport permit, because if you add in the 432 days that expired on November 26, 2020, the statute that Mr. Rutherford referenced is basically unclear, is interpreted multiple ways. Some interpret it to say a transport permit under all conditions with a conveyance system initiated or not initiated, that it would automatically sync with the operating permit. Others interpret that new legislation from 2019 to state that it's an only automatic sync if you've initiated your conveyance system. And to my knowledge, Recharge has not initiated its conveyance system. So District Council is recommending that you follow the rules, which would require a renewal action from the board for the transport permit.
Thank you.
I would also, though, add, just, with all due respect, Rule 6.5A of your rules says, and I'm quoting this verbatim, if construction of a conveyance system has not been initiated prior to the issuance of a transport permit, the term of the transport permit shall be for a period of time commensurate with the time of the operating permit for the well.
Okay.
President Talbot.
Yes.
This is Michelle Gagnes. May I just quickly respond because we didn't hear from Recharge's counsel until after we had spoken?
Sure.
I wasn't sure why that was happening. I should have asked.
That was my mistake, and I apologize.
Okay, thank you. Quickly, Natasha, I'm in that camp that doesn't read 1066 to require that a 3-year permit with no effort to start a conveyance system during that term does not automatically sync up. That's my reading of it. I-1 doesn't seem to be pulled into the automatic of I-2 and J. So I think what should have happened here was after September 1, 2019, effective date of the legislation, Recharge should have asked to test that legislation and sync up its permit right then and there before September 21 of 2019 to extend the permit by syncing it with the operating permit. This 432 days was a convenient way to wait for whatever happened at the district, and what happened at the district to change its rule to say that 3 years is extended to sync up with the operating permit, irrespective of whether a conveyance system had been established. And that's not the literal statement of the rule, but that's what it means. The district chose to institute that rule. Didn't have to, by my reading of HB 1066, but did. And they didn't do that until October 16th of 2019. So, Recharge needs to figure out a way to rehabilitate its transport permit. So to make 1016-19 operative in your rules, they use the 432-day extension first, and then they get their sync up with the operating permit. You know, this should be the subject of a public hearing. This is what we talk about when we ask for accountability and we ask for transparency, and we're not getting it. And I'll end there. Thank you.
Okay.
President Talbot, might I respond?
Sure.
So there hasn't been much focus on Rule 6.6, and 6.6 does sync up the transport permit with the operating permit expiration upon renewal. We read that rule to, both follow Chapter 36 and then follow what we thought was the intent of the legislature with Chapter 36. It still gives the board some oversight of these transport permit renewals, which the board sought to have even before the 2019 amendments to the rules. So Chapter 36 doesn't require a public hearing here, but the district has kept some kind of criteria and discretionary review with the board under Rule 6.6. And that is, those criteria are listed under 6.6C.
Okay. I want to bring this focus back to the board. As I stated, this is an action item tonight. The board has indicated they do not wish to go into executive session to have any additional discussion with legal counsel. We've heard both from the applicant, the public, and our board attorney. I will open the floor to a motion.
Mr. Chairman, Samang here again. I've got one question that's not quite clear in my mind.
Okay, please do.
What was the original expiration date of the transport permit?
I'm pulling that up for you, Director Samang. So 3 years from January 1st, 2017. Is that right? No.
That's incorrect. That's the operating permit, not the transport permit.
Okay, September 2019.
2019.
Let's get Mr. Semane's question answered. And if
Forgive me, Director Semang, it's September 21st, 2019
Was the original expiration date.
of the transport permits.
Okay. And what was the effective date of the legislation that mandated linking them up?
September 1st, 2019 was the effective date of House Bill 1066.
Thank you.
Okay. Cheryl, do you have any other questions?
Not right now, thank you.
Okay. Again, I'm going to open the floor here for a motion from the board.
Mr. President, somebody's got to do it. And the way that I view it is that the legislation came into effect before the permit expired.
Mm-hmm.
And that being the case, I think it was extended, and so I would have to move that the necessary paperwork to get it done be approved.
Your motion is for the district to process as requested amendments of the expiration dates pursuant to Rule 7.2C. That's what's stated on the agenda.
That is, yes, that is my motion, the way I see it.
Okay. Is there a second to that motion? Okay. I will ask one more time. Is there a second to that motion? Hearing no second, the motion dies. Is there another or an alternative motion that the board would like to make? Well, in light of a motion not coming forward, I am perceiving that there is potentially some misunderstanding or clarification that the board, I think, needs on this issue prior to making a decision one way or another. So I'm going to say that we table this till the January meeting, and in that time frame, we come up with a better flow of information that addresses all of the questions that have floated up to the surface tonight that I think has created the hesitation in the board. Is that acceptable? And okay. If you don't,
President Talbot,
yes.
this is Michelle Gagnes. Point of order, what is the effect of the motion died and then we're tabling? What are we tabling at this point?
We are tabling item 11 until the January meeting, because as I've stated, I think the lack of another motion coming forward in light of the other one not getting a second is a lot of issues have arisen tonight that the board is hesitant to make until they can get some further clarification on some of these issues. The time of the permit, the expiration of the permit, which permit. I mean, there's been a lot of things thrown at the board here tonight. I myself have a couple of questions that I'm uncomfortable about. And so I'm just recommending that it be tabled to the January meeting so that the board, the staff can get together and address the issues in a more layman's perspective so that the board has an understanding of the action being requested of them.
Thank you.
You have asked us not to rush in. You have asked us to deliberate, and I'm trying to respond to the public request and to support the board in making the right decision. But
And we thank you for that. I just needed to understand where we stood procedurally.
okay, but
I would respectfully ask that you continue your public discussion of these items and rather than just retiring to executive session at the next meeting and then we don't really know what happened. So
I will. This item that is tabled tonight will be verbatim back on the January meeting. That's not to say that we will not go into executive session for some type of consultation for the board to have a clarification with the attorney. But at the same time, as I did this evening, I will take public comments from the public.
Thank you, sir. And I appreciate your indulgence for letting me interrupt you. And I do appreciate it.
Okay. Is the board comfortable with tabling this until January?
Yes, President Talbot, Herbert Cook.
Okay.
Yes, Mike, it's Pay Rogers. I think that's well stated, and I'm glad that you've done what you've done.
Okay, I have motion and second that we're going to table this until the January meeting. Hearing no, we will table this and move forward.
President Talbot Fleming, I abstain.
Okay, understand.
Phil Cook does also.
Okay, well, it is tabled and we will bring it up again at the January meeting and take it from there. Thank you for everyone's participation. There was
Forgive me one more time, President Talbot. What was the count on that vote to table, please?
We have all members present, so it was a 7-2 vote.
President Talbot, this is Natasha. So you don't need a vote to table this item.
Right, and I just wanted concurrence from the board that from what I'm recommending be done, I guess, in preparing. I just want the board along with me in what I've outlined to be done.
Okay.
And I've heard that in that motion, and that makes me feel like we're headed in the right direction. So one way or another, we can get this move forward in January. Okay. Again, thank you, everyone. There's been a lot of paperwork and trying to keep all this organized for tonight. Our next item is item number 12, a presentation by Gatehouse Water LLC regarding its activities to implement 10 production and transport permits after acquiring the permits in January 2020 from 4 Star USA. I don't know who is present this evening to present this, but Natasha, do you know who is present?
President Talbot, I believe Gatehouse is represented by Ed McCarthy, and he's on the line.
Okay.
But I'm not sure who's making the presentation.
Okay. Who's ever going to make, please step forward.
Good evening, President Talbot. This is Ed McCarthy on behalf of Gatehouse.
Good evening,
We
Ed.
have a number. Thank you. We have a number of representatives and folks here, and I'm going to let one of the co-managers of the project, Doug Fike, start off and do the introduction of the people here for them and about the project.
Okay.
Doug?
Thank you, Ed. Mr. Fike?
Yes. We start the principals in Gatehouse, be a little bit of background, a couple of minutes of background. The principals in Gatehouse have been involved in the creation, development, construction, financing of numerous water and wastewater infrastructure projects in the Austin area, in the Central Texas, Round Rock, Leander, all along the economic development corridor of the capital city. And in that process, we determined that there was a dire shortage of water that was going to support the economic development of Central Texas. We started looking into the permits that Four Star had. They had decided they wanted to divest of their permits and their asset, their leases and their permits and their wells. And so we looked into the resource and determined that under Lee County, there's 4 times as much water as there are in all of the surface reservoirs in Texas put together. So it's really a matter of balancing the resource with the needs that are prevalent in the central part of Texas. So we started working on that project with Four Star and almost 3 years ago. And in the process, we started doing our due diligence with respect to the communities in this whole corridor. And in that, we talked to the majority of the communities in Williamson County, Georgetown, Round Rock, the Brazos River Authority, Jonah, Liberty Hill, the Chisholm Trail system, on down to Pflugerville, down to Austin, and determined that there was a real shortage of water that was available. So we pursued Four Star until we were able to acquire that asset from them. The principals involved in Gatehouse are the sponsors of a 501(c) corporation. It's a nonprofit entity that supports the Gatehouse, which is a project that was built by one of our primary principals in Fort Worth. And it's a residential center for women escaping crisis. So the majority of the revenue, if there is a revenue stream to be developed with Gatehouse, with this resource, it will inure to the benefit of a nonprofit charity. We started in the process of working with Four Star. We also started working on relationships with these municipalities, and among those were Georgetown, the Brazos River Authority, Round Rock, and the rest of the northern Williamson County constituents. In that process, they ran into COVID. Our closing was in January, and of course the COVID results came about in February. And so the Georgetown City Council decided they were going to delay any action with respect to any other water resources that they were investigating, because they were more concerned about the budget in the city because of the loss of sales tax. But their goal was to bring that about in the time that's necessary to deal with the issues at hand and to come forward with create a relationship with another resource, because the surface water resources are used up, and the Brazos River Authority has a shortage in their authority downstream, and so they're looking for ways to help the communities that they serve now, as well as the constituents they have down basin. So the facts are that there's such an abundant supply of water, and if it's treated the way that Lone Star has implemented or is implementing a plan that we are participating in with the monitoring well system and all the rest of the protections that are necessary to balance the resource with the needs of the communities around. And Ed's going to get into more of that, but I just wanted to give you a little background on where we have been. So the presentations you'll hear after this item on the agenda will crystallize that in your all's minds, I believe.
Okay. Thank you, Mr. Fike. Who would you like next to speak to the board?
Mr. Talbot, thank you. Ed McCarthy again. I'm going to do a brief statement and then we'll turn this back over to questions to the board. We have, in addition to the principals of the Gatehouse Water LLC group, our engineer and our hydrogeologist, at least one of our landowners I've seen, Mr. Gary Brown, is also here listening. As you're aware, we've been watching and listening to the board and the district's comments and working with staff with respect to concerns about production, monitoring, aquifer conditions, things like that. You'll recall that when the 4-star permit was granted in 2015, based upon the science that was in place at that time, we, as part of our settlement in the appeal from the permit decision, worked with the district to develop a monitor well program agreement. And as part of our settlement, that included requirements that we would build multiple wells in addition to a monitor well that had already been built as part of the project in the well field, to observe and monitor impacts, if any, that the production from the project might have on the Simsboro aquifer. And we had coordinated that post-issuance in discussions with the district's general manager and its hydrogeologist, Andy Donnelly. That effort did not come to fruition because of as Mr. Fike noted, the decision at the corporate level of 4-star to divest of the asset. But as soon as the Gatehouse group picked this project up, they got the engineer and the hydrologist back on the team and began talking about the monitor well program and have been listening again, as I said, to the district. And I want to be clear that there is a lot of flexibility in our monitor well agreement, and I've been in discussions with the general manager and general counsel for the district about that to address the issues that have developed since 2015 when the agreement was initially entered into, to look not only at wells that would be completed in the Simsboro, but wells that would be completed in adjacent aquifers that are believed to be in communication with the Simsboro, so that we would be able to monitor and evaluate any potential impacts both in the Simsboro and in the adjacent aquifers, primarily those above the Simsboro. As you all know, the Simsboro is the deepest of those formations, and be able to address any concerns that might come up based upon those conditions. So Gatehouse is prepared to work on that. Of the 10 permits that Gatehouse has been granted, authorizing 10 wells, 3 of those wells have been completed as public water supply wells approved by the TCEQ. At the time of acquisition, and one of the steps in the acquisition was a renegotiation of the various leases that are associated with those 10 permits, so that we could not only update the landowners, make them comfortable with the project, but Gatehouse went the extra mile of not only including the community in the overall revenue stream of the project by paying them royalties for production of their resource that was being granted, but also made them participants in the revenues that would be generated from the sale of the water above and beyond the royalties in the same type of capacity that the principals of the Gatehouse group, including the foundation, would be participating in. as Mr. Fike said, the foundation, charitable foundation, which I know that Mr. Totten is aware of because I've given it to him and Ms. Martin. The website, you can Google the gatehousegrapevine.com and learn more about this great institution. It's the primary beneficiary, and it's the purpose that the project was picked up, was to create a long-term revenue stream in the form of annuity that would help this foundation continue to be active and provide the great services it does. As Mr. Fike said, timing wasn't great in terms of the negotiations and the ability to complete a contract yet. COVID has hampered those efforts. However, the efforts have shown fruit already. We had filed a response to a request for information from the city of Round Rock, and in the last 45 days received a request from the city for supplemental information regarding our project for their review, and our deadline for responding to that was actually today. So we had actually, in preparation for the meeting, we're spending a lot of time completing that and getting that timely filed with the city. You're going to hear from a gentleman who is actually an employee consultant, outside consultant for the city of Georgetown. After this agenda item and the next agenda item, Mr. Jim Briggs, he's the former director of the utility system there in Georgetown, has retired, is now consulting. As part of his consulting work for Georgetown, he will be speaking about the regional interest in developing regional water supplies by BRA, Georgetown, Round Rock, and they're coming together, and we previously briefed, and as part of the renewal application I filed on behalf of Gatehouse earlier this fall, we've got a copy of the memorandum of agreement between those three entities related to their efforts to develop a regional project. And what Gatehouse did when they picked this up was to go and solicit that regional concept, so that rather than having multiple straws in the aquifer, we develop a project that could be relied upon by a group of municipal water purveyors serving a large area in this part of Texas, Williamson County, including Lee and Bastrop County, and then the other two counties that were authorized to transport water to, Travis and Hayes County, which, while not Bastrop and Lee County, we have no plans or intent to take all of the water out of the district. But what we are trying to do is bring water to meet the regional demands in the Capital Corridor, where so many people from Bastrop and Lee County are gainfully employed and look for their income and livelihood. And this is something we're trying to support, as well as the growth in the region. And I'd be happy to answer any questions that board members may have. Otherwise, I'll turn it back to you, Mr. Talbot. And I thank you for the time and the opportunity for us to be here today.
Thank you very much, and appreciate the time that you've taken this evening to update the board. At this point, I will recognize the board. Do any of the board members like to have any particular questions for Mr. McCarthy?
Yes, sir, I do. It's Herbert Cook.
Okay, Mr. Cook, you got in first, so you go first.
Mr. McCarthy, how many
Yes,
acres
sir.
do y'all have under lease for wells?
Over 10,000.
And all those leases are current?
Yes, sir, they are. They're all fully paid up and all current.
And where are most of these leases at?
They're all in Lee County. The
Where
district
out
has a
specifically
map.
in Lee County? We're out specifically in Lee County.
I'm not without the map in front of me, Mr. Cook. I apologize. I'm happy to get you a copy of the map, and it's on file with the district and included on our renewal application, and Mr. Totten could provide it to you. I apologize. I don't have a way to show it to you tonight.
Okay, the reason I'm questioning some of this is because of the well on Gary Brown's place.
Yes,
And
sir.
I don't know how far it is from I know Jimmy Hooper has one in Lexington. And what type of a drawdown are we talking about if we start pumping Gary Brown's well?
I'm not a hydrogeologist, so I can't accurately answer that question for you at this time.
The other
We
question
have
I have
three
is
wells.
right. Yes, I'm sorry, I didn't mean to interrupt you.
No, I appreciate that, sir. We have 3 wells constructed, and under the phase, which is, I forgot to mention, not all the board members were here when this permit was first granted. In addition to the model the district's been following of monitor wells, programs are being incorporated into large permit projects like ours. We also included the phased-in concept, and as the permits are currently drafted, the initial phase has a maximum production of 12,000 acre feet. And the 3 wells that are constructed are capable of producing that volume of water, and they are capable of being pumped and rotated in order to manage the drawdown and protect the aquifer. And obviously we have 1 monitor well currently in place in the middle of the well field, which would immediately be able to monitor that effect. And before we would begin production under the terms of our monitor well agreement, we're required to construct the additional monitor wells at locations approved by the district's general manager, and have those online before we start any commercial production. The only production we're allowed to do at this time is for purposes of testing and working on the wells. No commercial production for sales.
Okay, and the other final question I have is there is a property across from Gary Brown's property up there in the upper end of Tanglewood, the A-Dog Ranch, which we've given them a permit for 10,000 acre feet, if I'm correct on that. And that seems like that's going to cause conflict between Gary Brown's well and their well if they ever produce it.
I'd have to ask our hydrogeologist to evaluate those 2 separate permits, Director Cook. I don't know the particulars of the A-Dog Ranch permit.
Yes, sir. Yes, sir. I thank you for your input. Thank you, sir.
You're welcome, sir. Thank you for your questions.
And just a point of clarification, the A Ranch permit was, I believe, 444 acre feet.
That's all we gave them. I thought it was 10,000 acres.
No, sir, I believe it was 440. It was below 500 acre feet, as I recall.
All right, then I stand corrected on that.
Good. All.
Anyone else wish to address?
Mr. McCarthy, this is Phil Cook.
Okay, I guess we got switched. I apologize. Go ahead, Phil.
I'm recognized. Thank you. Would you tell us more about the 3 wells that you have? Are they complete, or are they under construction, or do they have pumps in them, and are they presently being used? Would you just elaborate on that, please?
Yes, Mr. Cook. As I understand it, the wells are basically completed. They do not have pumps in them at the current time. They will be outfitted with pumps when we get to the point of commercial operation. They have had pumps in them and were used for pump tests and for water quality analysis back in the 2015 timeframe, as I recall. So we have water quality reports from those wells on file with the district, as I recall also.
In regard to your monitoring well system for your wells, as I read the permit, or as I understand the permit, I guess I should say, only recharges designated wells can be used by the district in monitoring the effects of your wells on the surrounding area and surrounding aquifer formations and that stuff. You had mentioned that you were in discussions with the district about that. Would you tell us more about what your intentions are on that, whether you intend to become a part of the district's general well monitoring system. I just want to understand the parameters and limitations of that as you see them.
Yes, Mr. Cook. First, if you don't mind, and I want to be careful and correct. You mentioned recharge as wells. We're not. This gatehouse project, which is the former 4-star project, and there's a lot going on. I just want to make sure I'm clear.
I'm
I want to answer
from participating in the recharge. I'm sorry. All
okay.
what I said is it applies to 4-star.
Yes, sir. I understand. Well, the first thing I want to say is that the agreement was originally negotiated by 4-star, and 4-star is now out of the picture. Okay.
Yes.
We have the Gatehouse group, an entirely different group. No one who was with Gatehouse was with 4-star or a part of that. Okay. From a scientific standpoint, the continuity you have between 4-star and Gatehouse is a continued commitment to science. And that's why it was so important to bring back the hydrogeologist who was working with 4-star, and not only working with 4-star, but like me has been a part of this project on and off since its genesis in the late 1990s. And so that familiarity, experience, the work on the project as well as the work in the region goes to complement the science that's going on. With respect to the language of the existing monitor well agreement, I'm not sure that I fully agree with the way you described a potential. It is a potential interpretation. I don't believe it is the interpretation that Gatehouse would use or that the district would use, or that Mr. Donnelly and Mr. Totten would tell you that in the discussions even 4-star was having back in 2016 before the decision was made to divest of the resource, when Mr. Thornhill as the hydrogeologist and 4-star's representative Brent Covert were talking to Jim and Andy about developing the well field. The emphasis was on ensuring that the wells that were drilled by 4-star for the 4-star project would be set up and utilized primarily for that purpose. Obviously, the data that would be generated would be part of the overall monitor well system of the district. There's no way to do a disconnect between any particular well within the district and other wells drilled by or for the district. We had looked at and considered if other projects, and when the NDOPR now recharge project was granted and they had a similar requirement for monitor wells, we had talked, Mr. Thornhill and I, about the need to coordinate so that we, in working with the district, if recharge was amenable, we place wells to maximize the coverage of the wells so that you get the most accurate science that was possible to be developed. That again is the overarching objective and why we suggested a monitor well program. We weren't looking to try and have a monitor well program that could only be used to monitor 4-star. We were looking at one that was going to contribute to the science of the overall district's inventory. Now, with respect to that, in 2015, when the plan was developed, the emphasis and the discussion, and Jim and Andy, I think you're on. Andy, I think you're on also. If I'm inaccurate, I wasn't in the meeting, so correct me, but I believe that the reason the focus was on completing all of the new monitor wells in the Simsboro, because that was the aquifer of concern. It's a deep aquifer, and some of the science that has come out that has suggested the potential communication between the Simsboro and other formations like Calvert Bluff and Hooper above the Simsboro are something that need to be more closely monitored. That science that has developed since 2015, early 2016 is something we're aware of. And we have talked with district staff about the ability and willingness to drill wells in those formations or at higher levels in the Simsboro, not just deep to monitor just the Simsboro, but to monitor all of those aquifers so we get the benefit of that science.
What I hear you saying then is that you have no real fundamental objection to gatehouse wells being included in the overall district well monitoring system, and to be essentially, you know, an integral part of that, and there wouldn't be two separate systems, but just one.
Yes, sir. And again, I don't see how you have two separate systems. It's not like they're daisy chained together. And
well, I don't either.
So I'm not sure where that interpretation comes from. I will tell you that, you know, there was concern or a desire. Let me put it that way. I'm not even sure it was concern. 4-Star wanted to be sure that the locations selected for monitor wells would in fact be monitoring production from their project. And so that was the reason that there was a joint the language read that there would be agreement by both sides as to the locations. We didn't want to see because these wells aren't necessarily cheap. 4-Star didn't want to see the investment it would be making in drilling a new well to place a well at a location that was, everyone would otherwise agree, hydrogeologically impossible to be monitoring what was going on in the 4-Star production area. And so that was the only, I would say, limiting criteria that 4-Star was interested in. But to confirm your comment that the idea that these wells, the existing well in the middle of the well field and the new wells that would be added, either as newly drilled wells or if appropriate and acceptable, retrofitting existing wells in locations that would be thought to be desirable as part of this well monitoring program is a completely acceptable path forward for the project. And I will also tell you that the reason that the agreement that is in the file now is as high level and sort of 10,000 foot rather than ground level is because at the time it was approved and agreed upon, the scientists hadn't had a chance to sit down and talk about where should we put the wells. And so it was done as a conceptual document to be a guidance for the ultimate decision, with heavy input from Mr. Totten and Mr. Donnelly.
Thank you.
You're welcome.
Concerning the Brazos River Authority, Round Rock, and Georgetown, are they? Do you know if they are in the Region K water planning? In Region K for water planning?
They have, I'm sorry, sir.
Just where I'm going with this, I'm wondering if Region K or whatever region the cities and entities are that you've been talking about for the use of this water, I'm wondering if Region K has identified Lee County in particular, and the Lost Pines District as a source for future water needs.
I believe that the Williamson County entities, and BRA is obviously much larger than Williamson County, have areas that are in both Region K and Region G, and some areas in Region J. And whether or not, I'm sorry, I didn't mean to interrupt someone.
No, I'm sorry. That wasn't me. Go ahead, sir.
These entities are in at least all three of those particular regions. I believe that, and Mr. Briggs will be able to speak to this more directly because he's day-to-day more involved in the utilities operations for City of Georgetown historically, will be able to directly respond to the use of this water from the Lost Pines District as being in the regional planning documents. And as you are well aware, presence in the regional planning documents and even the state water plan is not a statutory prerequisite criteria for granting of permits or use of water. Its only real prerequisite status is for purposes of being able to secure funding out of the Water Development Board SWIP fund.
Just to be clear on this, you have no binding contracts at this time. Is that correct?
Not at this time, sir. No.
Okay. Excuse me just a second. Let me catch up with my here. Thank you. I believe that's all the questions I have of you. I have some additional questions for the district and some of the agenda items to follow. Thank you very much.
You're welcome, Mr. Cook. Thank you.
Do any of the other directors have questions for Mr. McCartney?
President Talbert, Herbert Cook, I have one more quick question, and I'll.
Sure.
Mr. McCarthy, how deep are the two wells that I was referencing to, Gary Brown's and Jimmy Hooper's wells? How deep are they approximately?
If I might, Mr. Cook, Mike Thornhill, are you still on? Can you answer the depths of those three wells? I don't want to misstate it. They're deep, but I don't want to misstate.
I think they're around 20. I don't have exactly the depth. It's been a long time, but around 2,400 feet. I think the top of the formation's around 1,600 to 1,800 feet below the land surface.
Okay. Thank you. Thank you very much.
Yeah. Yes, sir. Mr. Cook, I would add that on file with the district, and I'd be happy to provide additional supplemental copies if they're needed. I know the district's moved offices since we originally worked on this permit, but there are detailed reports on the completion of the wells and the pump tests and things that were done as part of the permitting process. And I know all of that detail is in there.
Okay, thank you.
You're welcome, sir.
Any other questions for Mr. McCartney? Mr. McCarthy, we thank you very much for your presentation and answering the questions of the board. I will close item 10. This is for presentation and no action. Item 13 is a regional groundwater supply presentation at the request of Gatehouse Water LLC, made by Jim Briggs, consultant for Brazos River Authority and the cities of Georgetown and Round Rock. Mr. Briggs.
Thank you, Mr. Talbert. Can you hear me on this system?
I can.
Okay. Great. I have a brief presentation I'll bring up as soon as I check this real quick. See if I can bring this up. Can everyone see the first slide of the presentation?
Yes, I can.
Okay. All right. Thank you. Introduction. My name is Jim Briggs. I'm with Utility Management Consulting, a principal, formerly general manager of the city of Georgetown, Georgetown Utility System, recently retired, but also retained to assist Georgetown on long-term regional water planning for their utility. I also, in one of the prior questions that will be connected, I'm sure, to a question later, I'm also a representative on Brazos Region G board as part of the Region G planning board and have been involved with that for several years. With that, I want to give you some background. I was asked to provide some background on the current relationship between the three entities and its impacts to this particular groundwater conservation district. Georgetown initiated contact with Brazos River Authority and Round Rock in March of 2020. The purpose of that was to evaluate the potential for future water supplies as a group central to Williamson County. Round Rock, the city of Round Rock, had previously requested an RFI on potential resources and was in the process of receiving those responses. Georgetown was considering options to conduct the same, but rather than independently do that, wanted to do that from a more regional aspect. The Brazos River Authority had also shown willingness to consider groundwater into their portfolio, and the groundwater portion of future planning was also discussed in the regional planning process as the Region G began moving towards completion of its preliminary draft IPP. All three parties have maintained a strong long-term partnership and relationship in water resource development throughout this area for many years. The parties agreed to move forward as a collective group. BRA eventually would take the lead in evaluation of options, and Round Rock would provide the RFI responses as an initial starting point. An MOU was executed in August of 2020 by the parties, and R.W. Harden was hired to conduct initial evaluation of the RFI responses ability of the suppliers to meet future needs. Expected initial evaluation was to be completed in the fall of 2020, with the final evaluations in the first quarter of 2021. The process will follow legally prescribed purchasing rules defined by the state of Texas. The final evaluation and recommendation would to each board council individually for public consideration and action, and evaluations and scoring shared during the presentation and discussion with boards and councils. Action would be requesting the authorization to negotiate with the intent of ultimate execution of a contract for water resources. The expected schedule of consideration would be in the late first quarter of 2021. And of course, all schedules today could be impacted by the current pandemic. The Groundwater Conservation District resources being evaluated are two resources in the Lost Pines District and one in the Post Oak Savannah District. The evaluation will include, but it will not be limited to, the capacity, number of assets, treatment of that supply, location, delivery point, price, and the financial ability for the entities to deliver under the contract, permitting, short-term and long-term considerations, regulatory, environmental impacts, consistency with state regional water plans. The Georgetown Integrated Resource Plan includes groundwater options to meet long-term needs for demands related to post-Chisholm Trail Special Utility District acquisition and some county other demands that exist that are currently not being met by any other water supplier. Round Rock Supply currently covers demand in its current supply-demand balance, but the RFP Rock to consider and evaluate if there are more effective strategies to their current plans. Brazos River Authority was to consider and wants to consider resources blended with its current assets considered conjunctive use for stability to long-term contract holders of supply and expected water demand growth within this part of Central Texas. That gives you a brief overview of the RFI and the purpose of what the three entities are working together on. I'm happy to answer any questions and provide any further background at your desire.
Mr. Briggs, in your presentation, you've talked about the steps and the evaluation of the assets and resources. At the completion of that, are you going to be able to project to the city of Georgetown and Round Rock what they would be looking at as a cost per 1,000 gallons of water for delivery to be used by those entities?
Absolutely. Price and cost of these resources will be evaluated. And it will be evaluated from the aspect of how quickly those assets would be activated and the blended cost among their existing assets within their current base rates and rate structure to see what that would do on a fiscal impact in the near term and the long term.
Thank you. Does any of the board have any questions for Mr. Briggs?
Mr. Briggs, does Gatehouse have any transport system for the water?
There, at this time, as part of the RFI process, we submitted a follow-up request to the submitters and defined a delivery point that will be located at University and State Highway 130 and asked them to submit on infrastructure to be able to deliver that point to that point. We will be receiving those within days, and from that point we will evaluate. As to the resources, whether they have ability to transport today or not, I would defer that to Gatehouse. We have not received that information for evaluation at this point in just days.
Well, Mr. McCarthy, do you know if Gatehouse has initiated any work on a transport system?
Yes, Mr. Ed McCarthy here. I'm sorry, I had to get off of mute. The answer to the question, quite frankly, is yes, in the sense that, one, we have 3 wells currently constructed and ready to put pumps and motors in and begin producing. Upon securing a contract, we have easements for portions of the right-of-way, and we have done substantial engineering work in feasibility studies and other analysis that have been presented both to the city, well, not both, but to the city of Round Rock in response, supplemented and updated in response to their latest round of questions, as well as presented to the Lone Star Regional Water Authority that covers the entirety of Williamson County. We have 2 feasibility studies that were performed by Mr. Coleman, the Gatehouse engineer. Those studies are part of the renewal application, which is on file with the district, reporting on that. So the honest answer is yes, we have initiated conveyancing system efforts. In terms of putting pipe in the ground to build a pipeline, no, at this time we don't have that. But that's largely because without a customer, we don't want to build a pipeline in the wrong direction and disturb the earth unnecessarily. But we have substantial work that has been done and completed.
I don't know which of you would like to address this question, perhaps both of you. As we've heard tonight, there are already wells going dry and pumps having to be lowered in Lee County pertaining to the Vista Ridge pumping. Your wells are, your well field is very close to that. And would it be safe to assume that additional pumping would cause additional drawdowns in the domestic wells, in that area? And which would engender eventually perhaps the district having to cut back on the non-exempt wells and the amount of water they can pump. Have you seriously considered that in terms of whether this project is viable?
Yes, Mr. Cook, I have no evidence of the statements that were made about the Vista Ridge wells or that there's direct communication or cause and effect from Vista Ridge pumping on the local wells. I also know we are in and have been in an extended flash drought condition. We're way behind on our rainfall, which has those same kind of effects with respect to impacts to wells. The project has had substantial hydrogeologic analysis done on it. There are faults, there are a variety of geologic conditions and things that would come into play that would affect whether or not there would be communication. But primarily, as I said earlier, before Gatehouse would ever begin to pump for commercial purposes, it would be required to have online its well monitoring system that would be able to predict and or monitor those kinds of activities, and action could be taken. And to the extent that the district is required because of conditions that are exercise its jurisdiction over the protection of the aquifer, there are lawful actions it could take with respect to curtailment. Again, I have no evidence of a direct cause and effect from one project to the other. I can assure you that Star and its predecessors didn't expend almost $30 million to develop a project that was going to cause the aquifer to go dry or for them to never be able to generate a revenue of penny of revenue because they couldn't produce groundwater. So extremely optimistic that the science is good. The additional science that's been developed since 2015, district's hydrogeologist, Mr. Donnelly, can well speak to, and I've heard him speak to the board briefing on the groundwater availability models that the Texas Water Development Board uses, have demonstrated that there is substantial water available, that production can be accomplished safely and done so without the threat of drawdown. But again, right out of the box, Star stepped up, and Gatehouse in acquiring the project has taken on and is working to enhance the groundwater monitoring system that would be put in place to ensure that proper precautions could be taken and management of the aquifer could be accomplished.
Thank you. So for the record, so to speak, you folks are well aware of the potential for having your production cut back because of drawdowns in the area caused by your wells.
I think everyone within the district's jurisdiction understands that the district has lawful authority to take certain actions, and so long as the district exercises in a lawful and appropriate non-discriminatory manner its jurisdiction, if that affects this project, the principals of the project understand that.
Good, thank you.
Is there any other board members that wish to address Mr. Briggs?
Mike? Mike,
Yeah.
it's Kay Roger.
Sure.
I wondered what the approximate distance is from the well field to University and 130, where you'd have to transport the water to.
This is Jim Briggs, and in order to respond to that, I would say I'm not sure of the exact distance, but Georgetown, Round Rock, and Brazos River Authority were instrumental in a 32-mile pipeline from Stillhouse Hollow to Lake Georgetown in the late 90s that was in the planning stage from the mid-80s. It is not foreign or inconceivable for Williamson County or the entities in this endeavor to construct and plan for a project of a long distance, and they have a track record and proof of doing so.
I just wondered how many miles of easement they're going to have to acquire in order to lay that, and what percentage of those easements. He mentioned you have some easements. I just wondered what percentage of the easements you've already acquired.
That would be up to Ed Parthy or Gatehouse to share that information.
Mr. McCarthy.
I don't know. I'm
Okay.
sorry, Mr. Talbot. Yes, sir.
I was just going to ask you to respond. I'm sorry.
I believe the distance that was asked is in the 30-plus mile range. In terms of easement acquisition, and that's not as the crow flies. That's following highways and right-of-ways that would be available pursuant to agreements with TxDOT to be utilized for things of that nature. And then we do have from the well field easements across some private properties that we would need. But the ultimate and final plan and easement acquisition requirements would be dictated by contracts signed and customer preferences for point of delivery.
How long do you think it might take to acquire those? It sounds like a big project.
Well, any project of this nature would be considered a big project. The Vista Ridge right-of-way that's been spoken about was acquired fairly quickly. The Alliance Regional Water Authority is currently acquiring right-of-way for its Gonzales County groundwater project to bring groundwater from Gonzales County over to Hayes County. It depends. Again, utilizing highway right-of-way is a very expeditious means to obtain the necessary easements.
But you would have to obtain those. You don't have any authority for eminent domain, do you, Mr. McCartney?
Gatehouse itself doesn't. Its customers may have that, and if they choose to use the powers of eminent domain, they could. And if eminent domain is utilized, acquisition of right-of-way can be accomplished fairly expeditiously, going through there's a negotiation process, but then you have a special commissioner's hearing, an award is made, and the amount of the award paid into the courthouse registry, right of possession, and the ability to construct and bring a pipeline online continues very quickly.
I'm well aware of the eminent domain process. Thank you. Any other questions from the board? If not, then we will end the presentation on item number 13. The next item on our agenda is item 14. And this calls for consideration and possible action regarding the request of Gatehouse Water LLC to renew transport permits for district wells number 5933122, 5933123, 5933217, 5933409, 5933410, 5933411, 5933412, 5933413, 5933504 and 5933505 from the Swimsboro Aquifer located in Lee County, which the district has processed as a request for a renewal of a transport permit pursuant to Rule 6.6. Natasha, do you want to give just a brief overview of this request?
President Talbot, I can, and Jim Totten may also have something to add. So applications for both renewal of the operating permits and transport permits were received by the district. And the operating permits are automatically renewed by the GM under the district's rules, in which that is allowed under Chapter 36. The transport permit renewals are the item before the board. As we discussed earlier, it's our reading that without the construction or initiation of construction of the conveyance system, that those transport permits would go before the board for renewal approval. And since the applications were received before the transport permits expired next month, those transport permits are not invalidated. And I'm available to answer any questions you may have. But essentially under Rule 6.6, there are several criteria upon which a board would consider to renew those permits. There's 5. The operating permit is still effective. The applicant is compliant with the permit and applicable authorities. There's inaccurate information that justifies non-renewal of any changes in the permit conditions. Number 4, changes to authority require changes to those permit conditions. Number 5, changes in the district's DFCs or the management plan would justify changes. And in the materials provided, I didn't see anything in the application or otherwise in the authorities that would justify non-renewal. And so if Jim has anything to add to this item, I'd pitch it to him now.
Mr. Totten, is there anything additional you would like to add at this time regarding this request?
No, sir. I'd just like to reiterate that, as Natasha stated, this is largely before you as a board due to the the fact that Gatehouse had not begun construction of conveyance. Had they if they had pipe in the ground, then this would be a non-issue. The permit would be renewed, similar to the way the operating permits are issued. But since I understand Mr. McCarthy says they've undertaken some engineering work and they're doing some planning steps, that kind of puts us in the spot where we thought it was best to bring it to you as a board to act on. So that's how this ends up in front of you.
Okay.
And President Talbot, Jim brings up a good point. I would add that Chapter 36, specifically Section 36.122, it does not give GCDs a definition of initiate construction of the conveyance system. So without that definition, I would caution the board to consider and things like easements and engineering studies to be initiation of construction. The more cautious route to take would be considering physical infrastructure to be initiation of construction.
Okay, thank you. I have had one request from the public to address this item. Mr. Steve Weir.
Thank you, Mr. President, and board members. And I've always been interested in Gatehouse water, very worthy project. My only question tonight is, as I read the operating permit, there is a condition to have a binding contract, and yet it's been automatically renewed. So I have a question as to how that figures into the permit, because it's not been acted upon or completed as it's written. And so, the same reason why you're bringing before the board the transport permit because the condition of a conveyance system has not been fulfilled. So both items should be coming before the board because technically they have not been completed. I think this is important. It's unfortunate, and I mentioned this in either the October or the November board meeting, that it's important for Lost Pines Groundwater Conservation District that despite the worthiness of the cause, they've been particularly stringent about how well owners, landowners, private property owners are received by Lost Pines District when they're initiating things. And so the same scrutiny should be applied to the permit holders. And in this case, if you were to show particular leniency in these renewing these permits, even though they have not fulfilled their contracted obligations, you would then be tipping your hand to show that you prefer well-moneyed people over landowners, and that would be a horrible appearance, or I would hate for you to give that appearance of impropriety. And that's my only thing. I from all the things I've heard tonight, I'm rooting for Gatehouse as a project for what they do and the endowment that this would fund. But I do think that you've set rules, you want to live by them, and they have failed. Mainly you can blame it on 4-Star, but they have not been able to achieve these permits. And so both should be before the board tonight for consideration. The last thing I'd say is to ask what was the project, Mr. Briggs, was how many acre feet is in those RFIs? That's the one thing that was never brought up, how many acre feet those regional project is seeking. And thank you all.
Natasha or Jim, would you want to respond to the question regarding the renewal of the transport permit in relation to the operating permit, I think, as Mr. Weir has raised this evening?
Yes, President Talbot, I would like to clarify for the board. So operating permits are renewed by the district without a hearing, and this is direction from the statute from Texas Water Code. They're renewed if an application is submitted on time and 2, the applicant is not requesting a change to the permit terms. You'll find that under 36.1145A. So under the district's rules, which are consistent with 36.1145A, the GM approves this renewal request without board action. So this is not a matter of leniency. The status of special condition number 8 in the permit, this is not, special condition number 8 is not in the rules. Special condition number 8 in the permit has no bearing on the renewal process of the operating permit. That process is provided by statute and the rules. And those rules were properly adopted by the district. So, I would caution the district not to stray away from the statutes and the rules, which are clear that this is an automatic process. And the special condition doesn't play into that automatic process.
Right.
And that special condition, Natasha, is what? What is a special condition number 8?
Certainly. So summarized, it's on the 5th anniversary of the issuance of the permits, the GM has authority to essentially, production value automatically goes down to the amount of the binding contracts in hand.
Okay.
So it's not a board action, it's automatic, and the GM can reduce that production amount.
But
so Natasha, isn't that automatic, and it doesn't require any action on the part of the GM? It just becomes part of the permit, whatever amount of water they have under binding contract. And of course, that's another question. isn't that automatic? And before you answer that, I wanted to get that question out there. This discussion spills over into item 15 below, and I have some clarifications I would like to ask of staff and council on that. And if it's your intention, Mr. Talbot, to postpone this either to the January meeting or at a special meeting to consider this might be a good time to do it, and we could all go to bed if you're going to do that anyway. Otherwise, of course, we'll proceed with the
I'd like the discussion to be completed before, and I want to see the reaction from all the board members as to what their desire is, and then I will proceed accordingly. Does any of the other board members have a question regarding, from staff regarding this item for action?
Yes, I still have questions.
Okay, take it away.
So Natasha, you're saying the operating permits automatically renew, but that does not change the special permit conditions that are associated with that operating permit. Is that correct?
That is correct. The renewal only automatically renews if there's no change to the existing terms.
That's right. Okay, so now that leads us to the transport permits. What about the transport permits? If I recall correctly, at some point in time in the past, we aligned the transport permits with the operating permits. Is that correct?
We do have a rule on the books from October 2016 that upon renewal, the transport permits and automatically sync up with the operating permits. So the expiration date would automatically be commensurate with the expiration date of the operating permit.
Okay, so is there any special condition in these permit conditions that would preclude us from processing this? Well, it says the district has already processed this request for approving the renewal of the transport permits.
So that processing of renewal is done administratively through the GM. And so that's not an item before the board tonight.
But even though it's an administrative approval, has the administrative approval been completed in-house as prescribed by law?
I'll let Jim jump in, but I do not believe they have been processed. They're still in the process.
That's correct. Not it hasn't been finalized to date.
Okay. So getting back to Mr. Fleming's question, they're supposed to sync up. Who takes action first so they can sync up? I mean, if we took action, does that set the date that they have to sync up, or does it wait until? I'm just trying to understand.
So, Mr. President, members of the board, a bit of history. These the 4-star now gatehouse permits have already been synchronized. That 3-year, the initial 3-year term on the gatehouse on the transport permit expired 2 years ago, and the board had already taken action to extend it by 2 years so that those dates sync up. As of today, both the operating and the transport permit are scheduled to expire in January.
Okay.
So those dates, those dates are already currently synchronized. Those permits would roll together. The reason this is before you, like I said, is because there was the question about the conveyance.
The conveyance system, the transmission system, right?
Transmission system, yes, sir.
Okay, and what Mr. McCarthy has told us is that they are working on that. And I know but there's no pipeline in the ground, but they have no contracts. So they have not built any pipelines, is what I heard. Correct?
That was my understanding, yes.
And wasn't it a requirement of the operating permit by a certain date that they have a contract?
So that is special condition 8, which says that on the 5th anniversary of the permit issuance, the contract, the volume of the permit, the annual authorized annual production is reduced to the amount that's under contract on that date.
Okay.
Jim, correct me if I'm wrong, but special condition 11 speaks to that. This permit is not subject to the district's rule on time limits for the completion of a permitted well or the operation of a permitted well. Am I reading that correctly, that they have forevermore to
So what that applies to is the nature of the phased permit, that they don't have to drill all 10 wells up front during the first stage of production. So under district rules, there's normally 180 days to complete a well, and then another, I believe, 180, possibly a full year to bring it into operation.
So there is no, go ahead, I'm sorry.
So when we started doing the phased production permits, with which this was the first, because there was going to be a decent chronologic spread between the day that the first well was drilled and the day that the last set of wells might be needed, the district waived the requirement for having all of the wells, the operating and production wells, in the ground within that, within a fixed time period.
Yeah, that makes sense.
Well, is there any date when phase 1 has to be completed and we move to phase 2? And is there any date when phase 2 needs to be completed, or are those times open-ended?
It is open-ended. Yes, so those are all fairly open-ended.
Okay. And I agree with that, Jim. It's just that we didn't put a time limit on when they had to be there. We just said you don't get any more until you get there, right?
That is correct. They can't produce until the monitoring wells have all been in the ground for at least a year. And then once they begin producing, they have to go through certain amounts, meet certain production thresholds for certain amounts of time before they can consider asking for increases in production. And because because of those unknowns, we didn't write a hard schedule into that.
Right. If we renew these transport permits, they will be aligned with the operating permits, correct?
Yes, sir.
And that will be a 5-year term, correct?
That is correct.
We can go however far we want to go. I'm going to make a motion to renew.
David, I have some other questions before you do that.
That's fine. You can ask all the questions you want to. I make a motion.
He has the right to make a motion.
I make a motion. We renew these transport permits. Since they do coincide with the operating permits, and there's not much reason to have an operating permit if you don't have a transport permit, and Gatehouse is a new owner, and we need to give them the opportunity. They have agreed to put the monitoring well system in. I feel comfortable with making a motion to renew this permit. These transport permits.
As listed on the agenda.
That's correct.
Do I hear a second to Mr. Fleming's motion to renew the permit numbers for the transport as stated on item 14 of the agenda?
Carl Steinbach moves to second this motion.
Okay. I'm going to have to do a board roll so that, before we vote, is there any questions now regarding this motion?
Yes. Referring to special condition 8, After 5 years, they must have binding contracts, and whatever amount of water they have binding contracts on, that automatically becomes the amount of water in their permit. Am I reading that correctly?
That's my read of it as well. Yes, sir.
So if we were to grant the extensions and synchronization of the operating and transport permits, there would be zero water in that permit. Is that correct?
Okay, again, let's take
They
a step
have
back.
no binding contract.
Let's take one step back. The permits are already synchronized. They're already running on the same 5-year term. So that's not before y'all tonight. So if you take action tonight and grant the transport permit renewal, both of those permits will be renewed, and come the 5th anniversary date of issuance, which is January 21st of next year, then the amount that's under contract will become the authorized production for that permit. Yes, sir.
So on January 21, which is a month and a few days from now, if there are no binding contracts for that water, the amount of water, the amount of water in their permit would be zero?
That would be my read of it. Yes, sir.
Natasha, how do you read that?
I read it the same way, Director Cook. Absent any sort of amendment, the production would be zero after January 21st.
Now, my other question is, what should the district consider as a binding contract? Should that be open-ended? Would a binding contract have escape clauses from it? Could it have an expiration term, say 15 or 20 years from now?
I want to make a point of order here. I don't think we can speculate tonight what a binding contract is or is not. That would have to be evaluated at the time it was submitted to the district, analyzed by our attorneys, and then converse that with the board to make a decision whether or not that's a binding contract. Because without something before us, we could what if that issue to death.
Okay, that's fine, and I agree with you on that, Chairman Talbot. But I just want to make sure that we develop some criteria for what is a binding contract, and not be in a situation where we're saying that's it. I know it when we see it.
I understand, and I concur with you that we should have a criteria as to what meets the standard of a binding contract, and that's something we should address immediately after the first of the year.
Thank you.
Any other questions on the motion? All right. I'm going to call Director Cook.
Phil Cook votes no.
Okay. Director Fleming?
Yes.
Okay. Director Steinbach?
Yes. Let's see.
Okay. Director Rogers?
No.
Okay. Director Cheryl? Billy? He's not here. Okay. Director Cook?
Yes.
Okay. Director Shoddy?
Yes.
Okay. Director Semaine?
No.
No. Okay. And Director Smith?
No.
Okay. We have 1, 2, 3, 4 no, yes. 1, 2, 3, 4 no's. It's a tie. And though I am at, I can, right, I have to vote in a tie, I have to advise it makes no difference which way I vote because it's going to take an affirmative vote of 6 board members for this to be approved. So in essence, the motion fails for lack of a majority. I don't know what.
President Talbot, so could you, I guess, vote so that we can have an account, or abstain either way, but we don't really have a count with your last statement.
I am going to vote no. Again, I'm just confused on a couple of issues. And if we need to call a special board meeting earlier in January, I will do that and try to get the full board in attendance if we need to do that prior to the normal board meeting. But that I would only call the special meeting predicated upon everyone being present. But, and I want to make it clear, my vote is predicated upon just some things I'm not quite clear on that I want to make sure that I go back through the permits and understand what we're going to be approving. So at this point, it does not pass either way. Even with my vote, it still doesn't do anything because there is not a majority. And I will leave this item again with the comment, I am willing to call a special board meeting after the first of the year, prior to our regular board meeting, if all members can make the special meeting to address this, and we can try to clarify some of the issues that I think will make the decision vote a little bit easier going forward. Okay?
Yeah, Mr. Talbot, who we're missing Billy?
We're missing Billy.
Is anybody else?
No.
Okay, so it's 5 and
it's 4 and 4, and then my vote makes it 9 votes.
okay, you're right. Your accounting is correct, and I'm an engineer and I'm wrong. Thank you.
I've had put a spreadsheet together since our first virtual meeting. I got a spreadsheet that I keep right in front of me.
I don't have my calculator. I'm sorry.
That's all right. Okay.
Mr. President, can I make?
President Talbot?
Yes.
Well, I would be in favor of having a special meeting to take a look at some parts of the permits that we discussed that I'm not familiar with.
Sure.
And also to take a look at the various rules that were cited, and I'm not real familiar with them. I just, like you, there's a lot of issues I would like to take a look at and be more certain of.
Okay. Thank you.
May I make a comment, Mr. President?
Yes, sir.
There are 10,000 acres of leased land that the landowners are depending on the use of their property rights, their water, and they have been in this project for 15 years. And a lot of those folks don't they're pretty serious about the opportunity to utilize their resources. And I think the idea that this project has been in place or working on this project for 15 years, there's been almost $30 million spent, it seems as though that we would recognize the times that we're in right now and the conditions that exist with respect to Gatehouse's involvement. And we've seen here previously the indication that there are 3 different municipal interests that want to access this resource for the utilization for their needs of their communities. So we have the landowners' needs, we have the community's needs, and it seems as though that it seems a little unreasonable to not recognize the fact that there's a time limit set by a previous, the agreement was done because of a settlement of litigation. And I think that we need to recognize that there are folks out there that do depend on the actions of the board to recognize their interest as well. So if there are other political interest or other reasons why the board has a negative attitude toward this, I think that we just have to look at the sign of the times and also the evidence that's put forth for the board today that there are municipal interests that have needs that could be satisfied by this resource. So that's all I've got. Thank you very much, sir.
Well, I would just respond back that I think the board is fully cognizant of the cost, the time frame, and the length of time that this permit has been pending before the board. And yes, there are property owners that have a financial interest that would benefit from this, but there are a multitude of factors as a district that we need to take into question. And my biggest question is, though you say you have an interest, you don't have a contract yet, there's a lot of engineering work when you're talking several miles of pipeline are you going to have to put in certain pumps, certain elevated or storage tanks to get it to the distance that you need? What's going to be your cost per thousand? And can you get that all done by the January deadline, or your contract's going to go back to zero? I'm trying to give you an opportunity to address those issues so that we have a better understanding of where the direction of this project's going.
Well, I can answer some of those questions. Ed, do you want to tackle that, or do you want?
Well, look at it. You can meet with Mr. Totten, and I will be glad to meet. But I think we have discussed this tonight. But I don't think that the board is being negative. The board is just trying to do the right thing. And again, I've negotiated in my previous career several water contracts, and they don't get done in 6 weeks. I'm sorry, sir.
That's right. That's the whole point, is that the idea that we have in 11 months, we have 3 different municipalities that have demonstrated their desire to utilize this resource for their community. It seems to me that there would be a reckoning with that, and also a recognition that the process for arriving at a contract is underway, and they say that that contract is going to be negotiated in the first quarter of 21. So it seems to me that there would be a recognition that there's municipal interest that want to arrive at a contract. We've got COVID that we've had to deal with, and if there's some not some recognition for what the conditions are in our country or our society dealing with trying to conduct business, then and you say it takes sometimes. We anticipated it would be a year to 18 months to come up with an agreement with a municipality, and here we are at 11 months, and we've got 3 different municipal interests that have expressed interest in this resource. So I'd like to see the board be to recognize that we need some additional time to continue our discussions with these municipal interests, and that's all we're asking for.
And that's why I have offered to call a special meeting to address that, sir.
Thank you very much, and I'd appreciate that.
Okay. We will move on to item number 15, the general manager's report. Jim?
Mr. President, members of the board, at this point in time, we've hit pretty much the 2 items that I had on my GM report, which were the transfer of the 4-star permits to Gatehouse and the processing of the Gatehouse request for renewal on their transport and operating permits. The only remaining items that I'd have to touch on are upcoming meetings for next year. We do have GMA 12 scheduled for January 15th. Again, that'll be a virtual meeting taking place at 10 a.m. on the 15th. And Region K will be meeting on January 27th at 10 a.m. Aside from that, I don't have any other upcoming meetings or anything else really to bring to y'all at this point in time.
Thank you, Jim. Item 16, discussion of Lost Pines Groundwater Conservation District legislation, related legislation, and/or activities occurring that affect or pertain to the district and groundwater. Is Mr. Ellis kicked in yet?
I'm here.
Anything you want to bring the board up to date on, Mr. Ellis?
In light of the very late hour, I want to really quickly let you know that the TWCA Groundwater Committee has all but completed its process. Most of the legislation that was brought to them has not made it through the process. Only 2 bills look like they're going to move forward. One has to do with the appeal of a desired future condition and what happens to a management plan that must be submitted while that desired future condition is under appeal. Essentially, to simplify it as much as possible, the bill would say that you continue to use the previously adopted desired future condition, even if it has been declared unreasonable, until it has been replaced by action of the GMA and the district. So we'll have to see if that legislation changes any as it moves through the process, but I think it's a good way to address a problem that came up during this last approval process.
Okay.
And the
go ahead. You done?
Did you have a question?
No.
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 Okay. There's one effort that's underway right now that I know of from the new, well, an existing state representative who's getting ready for the upcoming session. You may receive a request from Representative Kyle Biederman about asking for contact information for the board and the staff, asking about when the district was created, how it's funded, and the current level of drought condition. That has gone out to several different districts. So far, I've only heard from those districts in GMA 9, several of which are inside his district. So he may be limiting those requests to GMA 9, or he may be requesting of the entire state. I'm not really sure yet. We'll have to see if he expands that at all while he, as he looks at these answers. He has, the rumor is that he is discussing filing a bill to create a GMA 9 wide groundwater conservation district, either as an overlay over the districts that are already there, or in replacing and combining or consolidating the districts that are already there. So I think that would be a very controversial issue as it came up. It's a similar bill was filed to 2 sessions ago by then State Representative Jason Isaac. As if I remember correctly, didn't even get a hearing. He didn't request a hearing. But it has been discussed before for that area. So it looks like that's coming up again. The legislature still doesn't know for sure what they're going to do or how they're going to meet. There have been discussions about requiring COVID tests of anybody who comes into the building. There have also been discussions about requiring advance registration for public hearings in order to provide testimony. There's been some discussion of having remote testimony, but that seems like it's very disfavored because it's so easy to testify remotely. The hearings would go on for days. The only committee that has committed to remote testimony is the redistricting committee. So we'll have to see how this comes together as we're less than a month away before session starts. With that, I'm going to stop there because it is very late. If you have any questions about that, please let me know.
Okay. Item 17, I'm not aware of any conferences or meetings, but if you do desire to attend something, please let Jim know at the office. Just a reminder that the district offices will be closed the 24th and the 25th and the 31st. And that is kind of our calendar events at this time. And before I go into executive session, I owe Miss Natasha an apology. She is correct and I was totally wrong. The agenda is stated to go into individual items on the agenda if we deem necessary. So Natasha, I apologize for missing that and questioning you on that. My apologies.
Oh, Mike, you didn't owe me an apology for anything. It's a
No,
long.
I put my foot in my mouth. I owe an apology. Consideration of and possible action on schedule of the final hearing, which may be continued for the application of the Lower Colorado River Authority for operating permits and transfer permits for 8 wells in Bastrop County, SOA docket number 952-19-0705, State Offices of Administrative Hearings. There will be no final hearing presentations from the party or final action by the board on these applications at this meeting. Mr. Ellis contacted me prior to the agenda. He has been contacted by the applicant, and I said that he would have to go into executive session and review the item, the matter, and the status with the board. So at this time, we will get the time here correct. At 10:27, we will adjourn into executive session.
And Mr. President, I will recuse myself and I will see you guys later.
All right.
I'm also not participating.
Kay Rogers, I'm not participating either.
Okay.
And President Talbot, Jim Totten and I also won't be participating in executive session, but I can start the breakout rooms and not join them.
Okay. And who do I notify to get us back into regular session?
Well, I mean, you could either text me or I believe there's an option to leave the breakout room.
Okay, I think there is. That's right.
You
Okay.
can do that on your own.
Okay.
Natasha?
Yes.
So if I'm just hanging around and not going into the executive session because I can't, but will I just still be on the line when they come out of it?
Yes, you're going to stay in the what's called the main session.
Okay, good.
Is there going to be any action in an executive session?
There could be. Yes.
I see Greg doing this.
Okay, well, you're seeing him better than I am, so.
Okay, thank y'all very much. I will talk to y'all later. Happy holidays to everybody.
You too, Director Fleming. Okay, President Talbot, I'm going to get this started.
Okay, thank you, Natasha. And again, my apologies.
Oh, no worries.
And just to be clear, I thought the question is, would there be action taken during executive session? And there will not be.
But there may be after.
Action taken when we come out of executive session.
Yes, that's what I was.
Right. But Director Fleming is recused.
Right. I just want to make sure I heard the full question right.
Okay, one moment.
Somebody else joined.
Okay, all rooms, the breakout rooms will close in about 15 seconds, so they should automatically get put back in. Director Shoddy should be in the main session with us now.
Okay, I see Director Cook. There we go. We're all here.
We're all here. Okay, we came back into from executive session in the regular session at 10:47 p.m. Based upon our consultation with our special legal counsel, Mr. Ellis, is there any motion that will come forth before the board? Somebody?
Greg, did you hear that?
No.
President Talbot, could
Motion?
you repeat what you asked, Mr. Ellis?
Oh, no, I heard Director, President Talbot.
Okay.
I'm waiting to see if somebody's going to step up and make a motion.
Are we all?
This is Cheryl.
Okay, Cheryl's not. Cheryl, okay. How about,
I would,
go ahead.
No, I was just going to say, are there, other than just authorizing Mr. Ellis to go ahead and contact everyone to get the process started, is there anything specific that you would like in this motion?
I think just direction from the board to move forward with getting a final hearing scheduled in January by working with the party's counsel and pro se protestants.
Okay, so my motion is to give Mr. Ellis the go-ahead to start working with the protestants and other counsel to start going forward with the process in January.
Is there a second to that motion?
Herbert Cook, second.
Okay. All in favor?
Aye.
Aye.
Is there any opposed? Did we get it didn't sound like we got only about 2 responses.
Well, Samang said aye.
They're probably muted.
President Talbot, could you do a roll call like you've done on the other items, please?
Okay. Director Steinbach, are you in favor of the motion?
He's still muted.
Here,
Manny?
I'll unmute.
Mr. Steinbach, you're muted. Can you unmute, please?
Unmuted, right?
Carl, if you can hear us, could you please unmute in the bottom left-hand corner of your screen? Push the unmute button. And I've also sent you an invitation to unmute. Mike, do you want to call in the other directors?
Okay. Mr. Cook?
Aye.
Okay, Mr. Shoddy? Mr. Samang?
Aye.
Ms. Smith?
Aye.
Okay. Director Steinbach? I would vote aye, but that only gives us 5. I'll vote aye. That gives us 5, but not enough.
Well, for those of you that are old enough to remember Sam Rayburn, whenever the vote was not going his way and he was speaker, he would beat the gavel on the table and say, "Ayes have it."
We're going to try to call President Talbot. We'll try to call Director Steinbach right now.
Okay, if we can just get one more aye, then we'll have a majority.
Mr. Shoddy is here. He's muted as well.
I believe
I do have several clients that that have large boards that when they take votes, the president asks, is there objection to the motion? If there's not an objection, it is unanimously adopted. So if you can't figure out how to unmute, you voted yes.
That's right.
If we can't get a hold of him, that's what we're going to do.
Mr. Shoddy, we need one more aye vote if you're willing to vote aye.
Yes, I vote aye.
And
There
the
we go.
motion passes. Okay.
Yay.
We're there, I think.
We got there.
Okay.
Members, thank you very much. I appreciate your help, and I'll get started on that.
All right. Please let me know. And no other items are
Okay.
before the board.
Greg.
So I will adjourn our meeting this evening. I thank you all for a very long meeting tonight. Wish you all a very blessed holiday, and I'll look forward to working with everyone after the first of the year or sooner if something arises. Thank you very much.
Thank you,
Thank
Mike.
you, Mike.
Thank you.
Thank you.
Bye.
Thank you.
Thank you.